A very good evening to all of the esteemed panelists and the participants for today's webinar of CA Vichar Manch and Shri Rajke Batra Study Circle. This is the first webinar in this series, a first joint webinar of CAVM and Rajke Batra Study Circle. This is in the fond memory of our patron, our advisor, our mentor, late Shri Rajke Batra ji, who has left us in the troubled time of COVID. First of all, we will give a few moments of silence as our gratitudes and Shraddhanjali to Shri Rajke Batra ji. And then we will start the session. Just few minutes. I request all the participants to be on silent mode. Thank you all. So after a long time, we are meeting through webinar mode. Physically, we have done CAVM meetings in the month of February, but the time and the profession which is at this moment is requiring for more and more webinars on the current topics and the topics of the today's importance. Today we have chosen appellate matters and art and content of appellate of appeals and the appellate procedures. We have with us our esteemed member, our advisor, our one of the patron, Shri Advocate Shri Sushil Verma ji, who will take us through the art and contents of the appeals in GST. We have the honor of the presence of very eminent author Shri Rakesh Garg ji, Shri Sandeep Garg ji. We have the presence of Advocate Rajesh Jain ji with us, our eminent speaker and a learned advocate in the field and expert in the field of indirect taxes. We have Advocate Nitika Khanna ji with us, and we have our executive member Atulya Jain ji also with us. Dear participants, before I invite Sushil ji for his deliberation on the subject, I have few questions in mind which I would like to put to Sushil ji, and wherever it would be appropriate, I will request him to please elaborate upon that whether the right to appeal is a constitutional right, one, whether the appeal once filed at any forum, first appellate or the second appellate, whether it can be withdrawn by the appellant, whether the first appellate authority, that is Commissioner Appeal, can remand back the case, whether the second appellate authority, that is tribunal, can remand back the case, at what times it would be appropriate to file a detailed submission, whether along with the appeal form or it can be filed later on, at what time the paper book has to be filed, whether the additional documents can be filed at the first appellate and the second appellate authority, what are the appropriate subjects where, what are the appropriate moments and cases where directly a writ shall be filed. So all these questions and many more questions are in the minds of journal professionals also. I welcome C.A. Ravindra Jain ji also, our executive member. Before I invite Sushil ji, I will request Nitika Khanna ji to please say a few words. She is our special invitee today, and she is a very learned professional. I will request her to say a few words. Nitika ji.
Thank you, Manmohan Khemka ji. Good evening to all of you. I welcome you all to this webinar and congratulate CAVM and Rajki Putra Study Circle Group, who are the organizer of this wonderful and critical webinar. My sincere thanks to Manmohan Khemka ji, Rakesh Garg ji, and Sushil Verma ji to organize this first ever webinar on such issues which we professionals face on daily basis. The organizers have given me the task to say about challenges before the professionals. Friends, when GST was introduced in the year 2017, it was projected to be a good and simple tax. While it has enabled the government to earn record revenues, but when we talk about the word simple, it does not appear to be simple at all. The whole GST regime, even after 6 years of its implementation, has been very challenging. The law is evolving, and we all, including the GST officers, are looking at judicial precedents to have clarity of concepts and law. The most common issues which we are facing today include the cases of registrations and cancellation of registrations. ASMT 10, that is mismatch, search and seizures, refunds, attachment of bank accounts, and attachments of properties of taxpayers. Endless disputes for input tax credits, valuation issues, e-way bills, and transporters issues. And crucially, the demand and recovery issues through Section 73 and 74 and the portal issue. Last but not the least, the most contentious issue of prosecution and arrest of thousands of people in this regime, which has sent a chilling wave in the industry. While the GST law is still appearing to be in a nascent stage of its implementation, it is a big time struggle for professional and revenue officers to keep abreast with endless notifications and circulars on issues that virtually equates to rewriting the entire law again. Though the Act provides remedy by way of filing appeal, in absence of a GST tribunal, the remedy is rendered to be redundant. It is surprising that even after almost 6 years, why no consensus can be formed in setting up GST tribunal. The statutory remedy given to taxpayer by the parliament has been denied so far, resulting in huge backlog of cases and burdening the high courts. Young professionals perhaps were feeling a bit hesitant to go for litigation. Shri Rajki Batra ji was a person who was always accessible to each and every person, whether known or unknown. With introduction of GST and the issues that were being faced by the professionals, he, along with Shri Sushil Verma ji, conceptualized the format of grooming the professional to keep them abreast with the law, latest developments, and judicial pronouncements. And as a result, the study group was launched independent of anything else. Though we have not yet completed 1 year since the study group started conducting the classes, the results have been heartwarming. I personally know many young professionals are now doing litigations and successfully. With his vision to reinforce this bond of litigation amongst professionals, 2 teams, CAVM and Rajki Putra Study Circle Group, have come together and are conducting this webinar free of cost to have a large outreach and to help each and every professional located across India to overcome their hesitation and fearlessly practice litigation in GST. The icing on the cake is that Shri Sushil Verma ji will be sharing some important draft appeals covering important topics under GST that will help the professional to draft their appeals. We will be sharing the PDF file with all the participants shortly. Let us hope this team organize more webinars in physical, hybrid, or virtual form for the benefit of professionals. Once again, I congratulate them. Thank you.
Thank you very much, Nitika ji. And I think in the meantime, Sandeep ji has left. Before I invite Sushil ji, I would like Rajesh Jain ji to say very few words. And thereafter, I will invite Sushil ji, and I will also request Rakesh Garg ji to be interactive wherever and appropriately Sushil ji and Rakesh ji think fit during the session. So I request Rajesh Jain ji to say a few words.
Thank you very much, Manmohanji. In fact, I was just to be an audience in this session, and incidentally, I have been put up as a panelist. But nevertheless, congratulations to you, to your entire team, and all the participants, as well as all the panelists on the board for conferring on various issues which are touching each and everybody, whether the professionals or stakeholders or traders alike. Nitika ji has very well said that there are so many issues which need to be touched by the people, and this is one platform where we had organized initially earlier also during the COVID time. These webinars were organized. I remember that you had organized a number of seminars, but now when this is a seminar organized by you and Shri Batra ji study group, so this is a very welcome step. It will enrich all the professionals across the country on various issues which are very critical in nature. And every now and then when we see amendments in the GST through notifications, some changes keep coming with which we all are related. So to deliberate on the subjects which have been chosen for today, I think it's a perfect and a wonderful platform. And the beginning would be very, very wonderful as Mr. Sushil Verma ji would be taking over and discussing and deliberating on the issues of appeals and the GST. Let's see what happens to the tribunal, in how much time it will get appointed. Thank you very much.
Thank you, Rajesh ji. Dear friends, Shri Sushil Verma ji is not a new name for all of you, but he is a name which I know that one of the person who has a zeal, an eagerness to give whatever he has inside him, and he has been in this service of giving or imparting knowledge for last so many years. And I must confess that many of the critical issues in VAT regime, in GST regime, it is my proud privilege to learn from Sushil Verma ji. We have with us eminent author. I have learned interstate VAT from the written sculptures of Rakesh Garg ji, and I must tell that interstate sale tax, central sale tax, I could understand only and only from the book of Rakesh Garg ji. Today we have both these learned speakers with us. So I would request today Sushil ji would be leading us, and he would be guiding us on the art and science both of the appeal drafting. And it is one of the unique seminar that wherein the formats of the appeals, the very precise documentations, how the appeals, the petitions, the miscellaneous applications, the other applications, condonation of delays, etc., has to be drafted, and the content has to be ensured that the appropriate content is being included into it. So I will not come much in between both the speakers, Sushil Verma ji and Rakesh Garg ji, and between the audience. I once again welcome all of you, and I request Sushil ji to take us and lead us to the art and science and art and content of the appeals under GST. Sushil ji.
Thank you to all of you. Good afternoon to Manmohan, the chairman of the session, and his team in CAVM, Ravinder, Atulya, Rajesh Rawat, and my dearest friend Rajesh Jain, I knew he will be there when I am there, though I didn't tell him to come because he's such a busy lawyer all over the country, but I thought he will be there surely. And my dearest friend Rakesh Garg and my brother Ashok Verma, and my sister, I call her Nitika Khanna. And you spoke very well, Nitika. Thank you so much. Now, see, this entire series was not conceptualized by me alone. We keep discussing with friends, for example, Rakesh. He has also contributed in this contents of what you are getting today. Rajesh, we keep discussing appeals on phones for hours and hours. So there's a lot of material that has come into my mind to share with all of you what we know. So this is not a kind of a question answer session, but we are trying to elucidate the conceptual framework for basically for youngsters. They are chartered accountants, company secretaries, or advocates. And it's my dream, because our time is over. It's that it's their time now, they have to come and take over, that they should learn. A lot of people tell me, sir, how do we do it? We have never done it. Well, life is always about the next move. So if you fear the next move, don't get into it. If you don't fear the next move, the move shall be successful. I can guarantee you that in Rajkiya Batra study group, we have done around 27 series of lectures on various subjects. And till now, out of 70 odd students we have in that group, all advocates, chartered accountants, and company secretaries, more than 16, 17 people do their litigation on their own today. Maybe small appeals, big appeals, wherever they need help of seniors, they do come. And it is our duty to help them, whoever approaches. And for me, Raj Batra perhaps was, after Ashok Verma, he was one of my best friends. We had nothing in common between two of us, except that he was equally concerned about the younger generation. I have always think this is a gratitude towards God. If God has given you some knowledge, if you can share. So I think we have to bow down before God that we are in a position to share what we have. And today I shall be sharing on appellate mechanism. We shall be covering only first appellate authorities, not the tribunals, because tribunal is not there, so no fun wasting time. And the concept of this particular webinar, which you have to bear for next 2.5 to 3 hours, is right from basics to condonation, to deposits, to additional evidence, to additional arguments, to question of law, what all you can do. And especially the routine things told to me by Nitika Khanna, Rakesh Garg, Ashok Sharma, our Celtex bar president, Manmohan Khemka. I have tried to cover those topics in all details. For example, ASMT 10. I had never seen in my life ASMT 10. So I saw it. I see what could be the issues. So there's a comprehensive note on various issues that can be raised in ASMT 10, and we are trying to give you answers. This entire appeal drafting is not loaded with judgments because we are teaching youngsters, but wherever judgments were necessary, I've tried to put in. And Rakesh Garg has given, he was out of Delhi and he came yesterday, and yesterday night he prepared on various appeal grounds on e-way bills. So you are going to have around 70-page document in PDF form. Immediately after the seminar, it has been given to Vineet, who is conducting all this, and it will be shared with you today. So let's start with appeal. Ritika, can you put up my PPT, please? Yeah. Now, friends, okay. What is an appeal? You can read this PPT. I'll tell you in general. Appeal is basically a complaint against a junior tribunal or a junior appellate authority or an assessing officer, what we call, to a senior officer, telling him, okay, look, the order that junior tribunal officer or assessing authority has passed is not legally correct. Therefore, my rights are affected and I feel aggrieved. So this is the precondition of filing an appeal, where you must have a genuine complaint against the order that affects your right. Only then you can be called an aggrieved party, giving you a right to file an appeal. The person who has filed an appeal called appellant, and the person against whom the appeal is filed, in few countries they called it appellee, or we call respondents, whatever name you give. So they are the respondent who are defendants or whatever you call. So friends, whenever we first learn to draft appeal, first you have to know how are you aggrieved with this order. Say for example, you did not have C forms and a tax of 10 lakh rupees imposed. So how can you be aggrieved? Because you didn't have C form and 10 lakh you were supposed to give. So now you have to make this issue into an aggrieved, saying that the following parties have not given me forms. I have done my level best. I made all the efforts to procure the forms. Forms are likely to come. I have got confirmations from the parties that forms are coming. Therefore, I feel aggrieved and I have a right to file appeal. So is the case in GST. For example, you file a return. You have not paid the return tax at all. Now, can you go and appeal? But you have to make out a case where you did not deposit your return tax and the order was passed imposing interest and penalty. Now you say, no, I want to file an appeal, sir. Mr. Verma, please file appeal. So Mr. Verma will have to see, can my client be aggrieved with this order where the admittee tax as per returns, he has not deposited, it's not paid. So can we say this order is illegal, and can there be a complaint against this order to a higher authority? So the first thing is, what is the purpose of appeal? What is the meaning of this appeal? This is the meaning of appeal. Remember this meaning as we go along. We will use this slide. Next, please. Now, there are a lot of confusion. People ask me, what are the tribunal? What are quasi-judicial authorities? What are courts? Now, these authorities in revenue, in up to tribunal, they have all powers as that of a court. They can summon the people, they can address your tax liabilities, they can take evidence, they can additional evidence, you can raise additional ground of law, you can argue the case, you can cite judgments, etc., etc. But they are not courts as per Code of Civil Procedure. That is why they are called quasi-judicial bodies or tribunals. That is why only advocates can appear in courts, and other professionals, company secretaries, chartered accountants, they can appear up to any tribunal, because tribunals are not courts. Only in courts categorized as courts as per CPC, Code of Civil Procedure, that only advocates are authorized. So remember the meaning of these kind of bodies. Next, please. Now, Manmohan Khemka had raised a question in his opening remarks, whether the appeal is a constitutional right. No, it's not a constitutional right, unless Constitution gives it. Writ is a constitutional right, but not an appeal. There is no inherent right of appeal in the appellant. If no appeal is provided, appeal cannot lie. Say, for example, advance ruling, appellate advance ruling, authority order, it cannot go to tribunal. No appeal can be filed, because the interplay of the definition of adjudicating authority and 107 takes it out. That is, that appeal right has been taken away by the statute. For whatever reason, this provision can be challenged in writ. How can they take away my appeal right? But appeal right is given by a statute. Therefore, there is no constitutional right. इसको पीछे लेंगे, इसको आगे लेंगे आप. Yeah, here, let's stop here, please. So therefore, filing of appeal is a statutory right and subject to conditions as may be prescribed by a particular special statute. Now there is a Supreme Court ruling, where this particular ruling you can read. CIT vs. Rai Bahadur, Hadotri Modilal Chamaria has held, it's also well settled that the assessing having once filed an appeal cannot withdraw. This was the next question Manmohan Khemka had raised, whether an appeal filed can be withdrawn. Supreme Court says an appeal, assessee filed an appeal and brought the machinery of the act into working, cannot prevent the appellate assistant commissioner from ascertaining and settling the real sum to be assessed by intimation of his withdrawal of the appeal. Even if the assessee refuses to appear at the hearing, the appellate assistant commissioner can proceed. There is a right of appeal, withdrawn appeal available, but this appeal can be withdrawn only if you are permitted by the particular tribunal or court. Otherwise, you cannot. Say, for example, there was an issue where you did not deposit C form that 10 lakh tax was to be levied. It was not levied in the order. And now you go and appeal, and you take this ground or whatever. Now you want to withdraw because you feel trapped. But the court can refuse to allow you to withdraw the appeal if, in their opinion, the correct assessment of tax liability cannot be ascertained. But my experience is, in 99% cases, if you file a withdrawal of appeal at any stage, the court can allow, unless the case has been kept for an order. Next, please. Ritika, next, please. Hello? Yeah. Now, when we say a right of appeal is not a constitutional right, but it's a substantive right. It is not a right of procedure. When we say substantive right, it means the right is given by a statute. It cannot be lightly taken away, but this can be conditioned. And therefore, read the red line. Right of appeal is a substantive right, and in respect of right of appeal and the provision of appeal itself, law applicable would be the law when the dispute first arose. This is a very critical question for first appellate authority. Supposing there's a deposit of 10% today, as of today, 29th April. On 29th September, they changed the law. No, deposit at 20%. Right? So there means the law, when I filed the return where the list began, where the dispute began as 29th April. So the law applicable to the appeal provision on 29th April shall be applicable, not on 30th September when it's been to do 20%. So read the Supreme Court in Hussain Kasam Dada. Is a very important, all of us know this 4 STC judgment. I'm reading the red lines only. A pre-existing right of appeal is not destroyed by an amendment if the amendment is not made retrospective by express words or necessary intendment. A provision which is calculated to deprive an assessee of the unfettered right of appeal cannot be regarded as a mere alteration of procedure. For the purpose of accrual of right of appeal, the critical relevant date is the date of initiation of the proceedings and not the decision itself. Therefore, in this case, it was followed in that case, in Bajaj Overseas case, I think done by Rajesh Jain. I'm not sure. So this law was applied. So therefore, the right of appeal is a substantive right given by a statute. It can be conditioned, and the law will be applicable when the proceedings begin. And in tax laws, normally proceedings are deemed to have begun when you file the return. That initiation, and especially in VAT laws, when return itself is under section 59 in GST, is a self-assessment order. So therefore, remember, whenever we face this situation during first appeal, you have to remember this law. What was the law available on that particular date? Next, please. Now, this condonation of delay. Here we will spend 5 minutes, little more than 5 minutes, because this is a very critical question. Now, once we say this is not a constitutional right, because when you have to file a writ, there may be certain times, but it can be filed even 5 years after, 10 years after. But if you are filing a statutory right, you are exercising a statutory right, a substantive right of filing an appeal, you are governed by the limitation as set out in the special statute. Now, if special statute says you have to file appeal within 60 days and delay can be condoned only by additional 1 month, please remember, buddies, you have time of only 90 days, not 91 days. Supreme Court, there are a series of judgments on this issue. In other words, you have to try to file the appeal within the period given by the statute. Let us say in GST law, 3 months, section 107. You have to ensure you file appeal within 3 months as mentioned in section 107. The condonation period is not a right given in the statute. It's a discretion given to the appellate authority whether he wants to condone delay or not condone delay, for which you have to create a sufficient reason. That is why in COVID 142 judgment of Supreme Court, they said whether period condonable or non-condonable. If they had not used the non-condonable, there would have been problems for all of us to apply for extension of limitation due to COVID. But here is clear. You have to file appeal within 3 months from the date when order is communicated. We will discuss a little later what is communication. And if you are not able to file appeal within 3 months, then you have to move a condonation application for delay. There is a performa we are giving on condonation affidavit. A condonation application generally should be accompanied by an affidavit. Generally, it's not mandatory, but a lot of courts have held once you file an affidavit, the authenticity of your argument and the reasons for delay, you are affirming on an affidavit. Because you file a wrong affidavit, it's a criminal offense. That's why we normally file affidavit. Now, somebody says that Section 5 of Limitation Act can be applied in such cases. The answer is no. Once a special statute has restricted the limitation of filing an appeal, Section 5 Limitation Act generally will never be invoked by High Court or even Supreme Court. The Supreme Court in series of judgments have dismissed this. No, we cannot condone delay. Only under Article 142, where Supreme Court has a constitutional power to pass any order they think fit for the general public benefit, that they have the power to condone delay. Otherwise, no. That is why in COVID-19 period, such delays were condoned. So we have 1 or 2 judgments on this. We'll read them quickly. The legislature has conferred the power to condone delay by enacting Section 5 Limitation Act in order to enable the court to do substantial justice to party by disposing of merits. But in GST, except High Court or Supreme Court, there is no unfettered power to condone delay. Both appellate authorities and tribunals are restricted for condonation of delay, whether the appeal is filed by the government or by the revenue. Next, please. Now, many times a question comes for all of us, right in the very first appeal. You say that a claim was not raised before the assessing officer in the facts of relevant that are on record. So if in your returns, all those claims were made, or in all document or other summaries you filed, claims were filed, but you did not press for the claim. Now, a lot of people think that such claims cannot be made. The answer is no. The claim can be tried and we should file the claim. And I'm giving you 2 High Court judgments, which are fairly recent. First is Supreme Court, such a claim is possible for the first time even before the tax appellate tribunal, CIT versus so-and-so, and so-and-so. And they say if the function of assessing authorities is to adjust the tax liability as per law. Therefore, if certain claims were not raised and there are documents on record to show those claims were made, then it is possible to raise such claims before the appellate authorities as well. But there are other rulings. For example, the Supreme Court in income tax ruling in Godrej case, they said if you did not revise the return, claim is not possible. This is only a solitary ruling. But here we're not talking of revision of return. We are taking claims, which claim that were made before the assessing authority, but we did not press or he did not give relief. So we have to distinguish between revision of returns and the claims made as per documents on record. Now, next is additional ground of appeal. Now, supposing when you filed an appeal, you took 6-7 grounds. Now, after discussion with colleagues or after getting wiser that this ground should also have been taken, you have to move a separate application before the authority that a certain ground has remained to be raised in appeal. I want to raise this. For example, in income tax, you have section 250 subsection 5. Now, such additional grounds are allowed. Now, what the distinction given by Bombay High Court is that it is not the same as fresh claim in appeal, in as much as fresh claim means a claim which was not made before the assessing officer. Additional ground arises out of the order appealed against, but for the reasons has remained to be raised. For example, an order was passed under section 73, which were time barred on the notice period as well as the assessment period. You did not raise this ground. Now, when you raise this additional ground of appeal, you are not making a fresh claim. You are only saying that this ground where the order was time barred, I did not take. Therefore, in the interest of justice, such grounds should be allowed. And it's also a question of law. So such grounds are normally allowed unless the court thinks it was a willful exercise or an unreasonable thing. Next, please. Ritika, next, please. Now, I have a lot of cases where our Delhi tribunal has been dismissing appeals of most of us. You did not take this in appeal memo before lower authorities. That is, if I did not take a ground before the assessing authority who passes an order like ASFD 10 base or 73, 74, such Caesar or whatever order he has passed, they say, no. The appellate authority has jurisdiction to enter an alternative plea raised during hearing of appeal. Now, most of the tribunals who are perhaps not well versed with this law, what Supreme Court says, they say, no, you did not raise this ground below, therefore you will not be allowed to raise it here. Now, Supreme Court says that is not correct approach to give justice. In Mahalakshmi Textile Mill case, which I'm reading the 4 lines, there is nothing in Income Tax Act which restricts the tribunal, and so is the case in VAT laws or in GST law, to the determination of questions raised before the departmental authorities. All questions, whether of law or of fact, whether of law or of fact. Now, a question of fact is which is based on your documents. Question of law is when you apply a particular law based on documents to draw an inference. In law, it means this. For example, a credit note, a GST credit note, a financial credit note. These are questions of fact. But when you discuss law, the GST credit note has a different legal ramifications, whereas the financial credit note has different legal ramifications. Therefore, all questions, whether of law or fact, which relate to the assessment of the assessee, may be raised before the tribunal. If for reasons recorded by departmental authorities in rejecting a contention raised by the assessee, grant of relief to him on another ground is justified, on another ground is justified, it would be open to departmental authorities and the tribunal, and indeed they would be under a duty to grant that relief. The right of assessee to relief is not restricted to plea raised by him. For example, I did not take a point of limitation before the first appellate authority or before the assessing authority. If this plea is made out, then the appellate authority duty bound to declare the order as time barred, notwithstanding whether I raise this point below or not. That is what Supreme Court is the concept of justice. And this justice, like in this case, assessee's claim of assessing of development rebate on certain sum extended repairs was rejected, and before the ITAD, the assessee successfully raised an alter plea that the said expense be allowed as current repairs. So though it's a judgment based on income tax, there are enough sales tax also, but I like this judgment because tax, there are both tax cases, both are paramaterials law dealing with tax. Therefore, this judgment by Supreme Court ratio can be equally relevant to our indirect tax laws. Next, please. Now, this is a new concept. We are not touching tribunal, but this is a new concept. We have in income tax, we didn't have this in VAT or sales tax. We have in GST. That is, if any party files an appeal, the other party can file cross objections to have an object. And these kind of cross objection are taken to be an appeal before the appellate authority. Agli hai, Ritika, ye nahi hai. Isse agli hai. Now, there are limitations. 3 months, 6 months, or whatever the limitations. So whenever we are faced with this situation from the revenue, whenever you file an appeal, they have certain time, let us say 90 days or 6 months or whatever time is given. We will discuss it later. We have the limitation period. If they do not file, it is your duty to immediately move an application. And now these objections cannot be filed, they are time barred. Because there also the condonation period is restricted. And I just saw somebody's answer that for the tribunal appeal limitation is unlimited. That could be, but the cross objections have limitations. Therefore, as an appellate lawyer, as a person who doing litigation and appeals, used to be very careful that the other party does not cross the limitation enjoyed by them in the law, unless those limitation period is condonable as per law. This cannot be condoned. Next. Now, many times it happens when we file appeal memo. They say no, appeal is irregular, dismissed. For example, you have seen in GST, because certified copy was not filed, therefore appeal is dismissed as time barred. For example, in the refund applications also, we had these issues. But there were application not subject to appeal. Here you have an order which is subject to appeal. Therefore, if there is an error or irregularity in the appeal memo, appeal cannot be dismissed in limine, and the appellant has to be given an opportunity to rectify the defect. Say, for example, you file an appeal on behalf of a company. You do not attach the board resolution authorizing the person who has signed the appeal to file the appeal. It is mandatory. It should be always be filed, and at least I always file. Now, can I say that the first level authority can dismiss the appeal? The answer is no. It's an irregularity. It doesn't go to the root of the appeal. So he must tell me, Mr. Verma, this board resolution is not there. Could you file and remove this defect? Yes, I can. There are certain cases in MCD Act, not in GST law or VAT law, where a mandatory deposit was not made in time. The Supreme Court even allowed to deposit tax and appeal was heard. But in GST, you have to deposit at the time of filing of appeal. So the language is different than the law we are discussing. Therefore, if there is an irregularity, then this, for example, appeal is not signed. If order is not signed, this is known as. If appeal is not signed, if there is no verification, we see daily in courts, they give you the opportunity, please file a fresh appeal, duly signed by authorized signatory. And for example, a chartered accountant or a lawyer signs the appeal. As professionals, we cannot sign the appeals unless there are emergencies. The person is outside India and he gives you an authority to sign the appeal. But the appellate authority cannot dismiss the appeal. You must say, okay, please get it countersigned by your client. Therefore, if there is an irregularity in appeal, for example, the original order was not annexed, which was supposed to annex. A copy was annexed, but this is no ground for dismissing an appeal. A lot of things are happening in Delhi GST department on such issues. That's why I'm spending a little more time on this. Next, please. Nitika, next. Now, these are, I would like to read this judgment, calculate discount. I like this judgment very much. I've read it many times. The department raised a plea before the incumbent authority that order of appellate commission was incorrect in law, therefore should be set aside, which objective is assessed on the ground. There is no specific ground in the appeal memo. The department sought leave to amend appeal memo, which was rejected, and appeal of the department was dismissed on the ground and necessary pleas have not been taken. Allowing the claim of department, the Honorable Supreme Court held, this is more important to read what we're discussing. The procedure adopted by the tribunal appears to us to be somewhat strange. The tribunal, instead of dealing with the substance of the matter, appears to have unduly influenced by procedural technicalities. We are also not impressed with the conclusion of the tribunal that appeal memo was not in accordance with law. No specific formula necessary for seeking relief at the hands of any court or tribunal if the necessary grounds are taken in the appeal memo. For example, I draft appeal differently. Mr. Khemka drafts, Rajesh Jain drafts the best appeal in the world. All appeals are very, very good because there is no pro forma given except you have to fill up that mandatory form. Whatever one form you have to file for the appeal. There is no other appeal format given except certain basics you have to follow. But in what format you give appeal? Yeah, okay. So therefore, Supreme Court said, no, you should have allowed the department plea, okay, whatever the plea they want to take, and then give a substantial justice. So a procedural irregularity. Our members in the past, they tell me they face a lot of this problem. So therefore, they have this copy of judgment with them. They can always use it. Next, please. Additional evidences. Now, supposing an ex parte order was passed and saying that based on evidence available on record, the claims of the assessee are not substantiated. For example, you claim a discount credit note and reduce your output tax liability at 10 lakh rupees. Now you're filing a claim return, that's not enough. Return needs verification. Now, ex parte order has been passed. There is no additional, you are facing a demand. Now, when you go to the first appellate authority, you have to move an application to file additional evidence in terms of various documents, whatever you have in your possession, in support of the claims you make in the returns. And the court has to permit you to, yes, we take it. Generally, 99%, this is allowed. Nobody refutes. But my friend, the problem is what evidence you have to bring on record. Let us say, for example, you are dealing with a supplier whose certificate of registration has been cancelled retrospectively under section 29(2) by the assessing officer on the ground. He was a bogus, he was running a fake invoice racket or good, whatever ground they take. Now you are faced with a very difficult question because 16(2) conditions are not satisfied. That is, he has not paid the input tax credit as per law because input tax credit that which he claims is bogus. That is, the department goes back to 3 levels: yours, your supplier, and supplier. So notwithstanding what judgments we have in or for or against this particular proposition, the contractual privities between Sushil Verma and say Manmohan Khemka, who is the supplier. Who supplies to Mr. Manmohan Khemka is none of my business. I have to prove transaction between me and Manmohan Khemka. Now, supposing you have to file an appeal on this issue. Now, therefore, in the recent judgment of CAVM for Karnataka VAT Act, Supreme Court has laid down certain evidences. You should try to get evidence and file an application of additional evidence. In support of this, I have this additional evidence because my input tax credit cannot be rejected on this particular ground. So whether it's credit notes or the documents, or let us say exports were rejected on the ground that there was no export inspector verification report annexed with the refund claim. Therefore, why reject refund for unutilized ITC for exports? Again, you have to think, what is the evidence that can clinch the case in your favor? Whatever you could have. Therefore, you have to annex this additional evidence, make the application under law for additional evidence, quoting a section and a particular rule, section so-and-so, read with so-and-so rule, and move an application and write with an affidavit. Okay, why was it not produced before the assessing authority? That is the key thing. Why did you not produce before the assessing authority? You have to answer the question to yourself and say, yes, now we need to file this. And say, this evidence is nothing new. It relates to my case. And in the absence of this, the justice will not be done to this particular case. Therefore, additional evidence, you can file, there is no bar. Next, please. Now, when we say appeal drafting is an art, why do we say it's an art? It's not when you write a love letter, start writing, even love letters require a beautiful drafting. You have to sit down with a cool mind. I mean, I have my friend Rajesh and we were drafting 2 or 3 reads together. And if you can believe me, you please believe, it took us 1 month on a similar point of law, about 16.4, to file out those writs. I filed in Telangana, I filed it somewhere else. And not that we didn't know the law. We said, how do we go about it? How do we challenge that 16.4 is not relevant? How we say that 16.4 is different from 16.2? How we say that 16.2 with notwithstanding clause is not relevant because 16.4 says no credit shall be allowed. Both are negative clauses. Therefore, drafting on appeal is an art. Until you spend time on what you are going to write, you must know the law. Don't jump. Judgment. No. If law was so simple, the whole world will become lawyers. It's not simple. That's why we call writing an appeal is an art. So what are the basics which the youngster must know and must spend time on this? First, remember, check whether the appeal lies or not. What are the conditions? We will read the section a little later. You should be an aggrieved party. And the order being appealed should not be non-appealable. There are 4 kinds of orders which are not non-appealable. And you should be an aggrieved party. And the order should have been passed by an adjudicating authority. So you have to satisfy whether you satisfy all these 3 conditions. If whether appeal lies. And how are you aggrieved? If the return tax was not paid, like I gave you example in the initial of my lecture, then what happens? Can you say you are aggrieved and file an appeal? Unless you make out a case. That is where this art of drafting an appeal comes. You have to make out a case if you want an appeal. You know, I declared an output supply taxable at 18%. However, I have a legal opinion it was taxable at nil. Therefore, I was not liable to pay tax. For ABC reason, whatever you can think of. Therefore, it's very important that you know that whether appeal lies or not. First, agreed party, order or decision. Now the words used in act are order or decision. A decision is the final culmination of your proceedings. Orders are which are passed in between. For example, order for pre-deposit. This is not a decision. It's an order for pre-deposit. This is also appealable. So both order and decision are appealable, provided they're passed by adjudicating authority and you feel aggrieved. Aggrieved means your rights are affected. Let me give you one more example here. Supposing, taking example of myself and Mr. Manmohan Khemka. Now, my ITC is denied because RC of Mr. Manmohan Khemka is cancelled retrospectively under 2090 on any ground. Now, who is to file the appeal against cancellation? Manmohan Khemka? Not me. But since I am an aggrieved party with his cancellation, I will also file appeal against his cancellation because his cancellation is affecting my rights. And therefore, I am an aggrieved. There are a series of Supreme Court judgments on this issue that such appeals are maintainable. Do not file frivolous appeals. As a good professional, it is your job as youngsters, especially youngsters. Don't get into making money. Your client can be in a serious trouble tomorrow if the appeal is held frivolous. For example, when you say a lot of writs are filed at High Court imposed costs. So that is a very serious stigma. So if you think appeal is not, he cannot file the appeal, tell him, boss, appeal is not filed, you are not deposited return tax, please pay and get rid of it. So only when you are convinced the appeal can be filed, you have examined this law and appeal can be filed, that you advise your client, yes, we are ready to file the appeal. Carefully study the assessment appellate orders and find anomalies and differences on facts. उसने एक्स पार्टी केस कर दिया. Let us say a simple case, एक्स पार्टी केस. कहता है जी आपने 3 करोड़ का रिटर्न में डाला था, मेरे पास इंफॉर्मेशन है कि आपने और भी सेल किया, मैं 4 करोड़ के करता हूं. एक्स पार्टी ऑर्डर आपके पास आ गया. There's nothing you can do. This is a decision taken. You have to file an appeal. It cannot go to High Court because you were negligent. So don't tell him I'll go to High Court. For going to High Court, there are certain set parameters. If you go to your judge and he will say, no, this is not a High Court case. I don't want your money. If you come to me, I will not file a writ. Unless I'm satisfied that certain things flow from this order that I can invoke Article 2 to 6 and go to High Court. So when you get that order, see वो 4 करोड़ उसने कैसे बनाया. 3 करोड़ तो आपका था, आपकी रिटर्न थी, आपने डॉक्यूमेंट नहीं दी, एक्सपर्टी केस वो उसको टैक्स करना था. अब देखिए कि 3 करोड़ में से क्या उसने आपको इनपुट टैक्स क्रेडिट जो अपने क्लेम किया उसका बेनिफिट दिया? क्या उसने आपको कोई टीडीएस काटा उसका बेनिफिट दिया? क्या कोई और आपने कैश लेजर में कोई टैक्स जमा कराया फॉर एबी सीरियस आरसीएम वगैरह के बारे में, क्या उसने आपको बेनिफिट दिया? और जो 1 करोड़ टैक्स बढ़ाया उसका क्या ग्राउंड था? अब इन 4 फैक्ट्स को लेके चलना है. पहले आपको डिसाइड करना है कि मुझे 10% किसका देना है. On your own, you cannot make deductions from the gross tax demanded by the assessing authority. You cannot take deductions of input tax credit. Therefore, generally, the general rule which at least I follow is that 10% of 4 crores, if it's only a tax amount, you will have to deposit. But when you draft an appeal, bring all those documents on record that favor your legitimate claims that you made in the returns. And all documents have to go in the form of a paper book. Another question Khemka had asked, which can be filed during course of hearing. But in your appeal grounds, you must write or even move a separate little application. If the paper book is voluminous, and I will seek permission of the court to file this during the course of hearing at the time of arguments. This can be allowed, there is no bar. Even if you don't write, still paper book can be filed. Other question was written submissions. Written submissions are normally with the after the arguments take place or before the argument take place, not with the appeal. Appeal should be technically drafted on very brief grounds, not big grounds. Unless you have a judgment of jurisdictional Delhi High Court or a Supreme Court or directly on a particular point, there is no fun writing judgments in the appeal. Unless you have 1 or 2 judgments that strongly favor you, that you can. Then ascertain the authority before whom appeal lies, jurisdiction. Now, jurisdiction, we have a lot of disputes. There are a lot of notifications by center and state, and section 6.2. In both the sections are differently worded. So we're not going into the law and jurisdiction, but you have to see where does the appeal lie. So if the order is passed by a central authority, appeal lies to that authority, not to the state authority. If the order is passed by a local authority, appeal lies to a local authority. If the appeal order is passed in UP, say for transport cases, so far we file appeals there only, not here. So you have to see from before whom the appeal lies. If when you study this jurisdiction issue, one more issue as a fundamental you must discuss, whether the proper officer who passed the order, was he a proper officer for your case? Subsection 91 of section 2 defines proper officer. Remember Canon India case, where on the issue of DRI not being a proper officer, demands by thousands of crores were quashed. You are not proper officer to issue these so-called notices. So examine whether the person who passed the order, let us say there was a search case, there was a raid case, enforcement case, and some enforcement officer who was not a proper officer, he passes an order. So if you know this law, you must take play if this order is not passed by the proper officer. And therefore, when you go to your jurisdictional appellate authority, this ground should be taken and take a ground forcefully that this order is honest, because the order can be passed by a adjudicating officer who is my proper officer, and this guy is not my proper officer. Next is ascertain the limitation period. I told you, first appeal 3 months, 1 month from date of communication of your order. If order has to be online, it has to be communicated on your GST portal. Once it's put on your portal, limitation starts from next day, whether you see the portal or not. You might say हमें फोन पे मैसेज नहीं आया था, हमारे को किसी ने बताया नहीं था, हमारे को फिजिकल नहीं आया, हमने देखा नहीं, हमारे घर में कोई बीमार था, ये था, दुनिया भर के बहाने हम लोग बनाते हैं वकील लोग. But answer is no. 3 months from the date when it's communicated and order is deemed to be communicated as per IT Act, as per as GST law. Now there are 3-4 High Court judgments also on this issue now, that order is communicated when it's put onto your portal. It is your job to see your SMSs from GST department or see your portal off and on, especially when you appeared before an authority and he's kept the case for order. So logically also, not legally, not statutorily, but logically also, you need to see your portal. So if 3 months have elapsed, your right of appeal has become time barred. The only latitude, the only leverage, the only relaxation which you can expect from law, that there is still 1 month for you to approach the appellate authority with an application for condonation of delay. Now, there will be condonation application 2. One is you were to make a predisposition at time of filing of appeal, you did not file. Now you are filing with condonation application. Now, there's a debate between 2 or 3 of us, but I will take when you file the appeal, that is the time of filing a predisposition. But the pre-deposit is normally linked with the statutory limitation, not with the condonation limitation. But notwithstanding these technicalities, you deposit money, move a condonation application, and there's a draft of condonation application given for the first timers. The condonation application should be drafted very, very carefully. You should draft as if the client will die tomorrow, especially when you're dealing with big stakes. Don't write, ye itna delay hoga, maaf kar do. No, you have no constitutional or statutory right that your delay should be condoned. It is the sufficient reason that you give in your application accompanied by an affidavit that will convince the appellate authority to apply his mind and say, it's just delay is condoned. Say, for example, you take a ground that I could not come because I was sick. Let us say today, I take a ground and the revenue says, Mr. Verma was giving lecture on the webinar. Well, you are committing a perjury in the court. So whatever ground you want to take in discussion with your client, you have to have a collaborative evidence annexed with this condonation application. You are medically sick. Now, supposing I have seen cases, in fact, I've done 2 or 3 cases in tribunal where we got away with this issue. Sir, I was sick. Medical record is 6 months before. Appeal was to be filed 6 months after. उसने बस सारा पूरा medical record लगा दिया 200 page का. No, that is not a ground for condonation. So condonation applications, you have to see whether the ground you have taken, is it applicable to the particular case? Do you have an evidence or any other corroborative evidence in support of the claim you make in application of condition delay, and whether does it make a sufficient cause? For example, you say the authorized person was not available. Let us say you're dealing with the case of company. Is he the only authorized person? There's no other person available. So these questions you have to keep ready with you if you are faced a situation where appeal was not filed in time for a YBC reason. Check the computation of tax. Say, for example, you claimed an item taxable at 18%. उसने 28% पे लगा दिया without giving reason. He cannot do it without giving notice to you in any case. So there also you read the order whether the tax rate applied by him is computation or whatever calculation the assessing officer done, is it correct? If not, you have to take a ground. Now, few people ask me 28 का 18 किया तो क्या मुझे 28 पे 10% जमा कराना है? My answer is yes. Because you cannot decide whether the sigma right or not. You can only take a ground if this was I claimed my return at 18%. It has been taxed at 28% without notice to me. However, as per evidence annexed, it is still taxable at 18%. And interest, whether in section 51 before levies interest, did you give you a notice for levying penal interest? That's mandatory today in GST law. Again, if it's not given, you take a point. But before you take this, see things on portal. Whether you received any notices on your portal, show cause, whatever notices were there. If they're there, your story will change. If they're not there, then you take this ground. Next, पीछे लो, पीछे लो, पीछे रीतिका, पीछे, और पीछे. Yeah, here split which errors are to be appealed and which error required to be rectified. If there is a computation error which is apparent on record, get it rectified. Your demand will come down. Therefore, your client will deposit 10% less amount than the original demand. So unless you study the order and do this kind of, minutely find out which errors can be appealed, which can be rectified. If they can be rectified, get the rectified order. Again, within 3 months, we lawyers who do high court will say, no, this period can be excluded. Don't get into all this. Not in today's world with tax laws. Immediately get it done and file appeal within 3 months. Supposing in 3 months, recognition order is not passed, then you still have a ground for condonation. And put a notice to the assessing authority, look how to file an appeal, please pass the order immediately. So अगर 10 करोड़ का डिमांड था, 3 करोड़ का रेक्टिफिकेशन था, तो आप 7 करोड़ पे 10% देना, आपको 10 करोड़ पे नहीं देना. So this little analysis can make so much of difference for you. Next, please. Next, Ritika. Now, this service part in rules, in GST or any rules, you have to see that how do you serve the other party. You must follow the rules. Service is very important. Unless you serve on the other party, the court cannot take cognizance of your appeal, it cannot pass orders. Therefore, imagine that 3 copy देना है, 4 copy देना है, 5 copy देना है, आपको पूरी copy देना है. So you have to be very careful that you file all copies, whatever required as per law, certified, indexed, whatever law says, you have to follow it. Number of copies you have done that. Next, please. Pre-deposit requirement. Now, right from service tax, if at 10%, it came to 7.5% after a lot of discussion with people like Manmohan Khemka, Jitendra Khemra, and the CA Institute, they were able to bring it down to 7.5%. But in GST law, language is totally different than service tax. It clearly says 10% of disputed tax amount you have to deposit at the time of filing of appeal. So once you file an appeal online, if you don't deposit 10%, perhaps, I understand appeal is not taken. Am I right, Manmohan? Appeal is not taken?
Yes, sir.
If you don't deposit 10%,
yes, the appeal will be invalid.
Can't file the appeal?
Yes, you cannot file.
Now let us
say
it
will not be admitted.
Yes. Now, let us say there is a very high stake demand. आपके 500 करोड़ की डिमांड निकाल दी, हुआ है महाराष्ट्र में 2 केस ऐसे हुए हैं जहां 350-400 करोड़ की डिमांड निकाली. They went to High Court. High Court dismissed because somebody raised a question whether instead of filing a first appeal and start the process of depositing 10% or disputed tax, then 20% before the tribunal, what happens now? When we say 10%, you have to read the order again. How was this order passed? Let us say this order said this demand is raised 400 crore on this ground. And you come to know from lawyers who do this work in High Court, Rajesh Jain or me or anybody else, they say, no. This point has been decided by Supreme Court. It's not taxable, full stop. So once you say, for example, in service tax, there were so many cases that these services cannot be taxed. For example, you're dealing with a government service and the officer passed an ex parte order taxing it in the absence of a documentary evidence, or other issues, so where you go to writ, first see jurisdictional issue. If the order was not passed by the proper officer, this is a fit case for jurisdiction. Only this ground you have taken High Court, no merits. Second, if the whole order was passed in violation of natural justice principles. In every case, in every law, there is a requirement of natural justice built in GST law. They must give you a notice. So, for example, 73, 74. Usually the word may issue, may serve, whatever. When the word issued come, he should issue the notice prior to 3 months, let's say, for example, 73 or 6 months, 74. Order has to be served within the limitation period as given in 75. So where this comes, where you apparently think this case is time barred and going to an appellate authority, nothing will happen. This is another case where perhaps we should approach Article 2 to 6, or where these notices were not given at all. For example, of 73, there are 2 notices have to come. One is a communication before the show cause notice. That is not a show cause notice. Show cause notice comes after the first communication. The limitation was show cause notice as per law. For example, जब उसने letter दिया, वो 3 महीने के अंदर था, from date of end of limitation or whatever. 73, 74, let's say, for example, extended again to September. अब वो show cause notice उसने 3 महीने तक कम दिया आपको. Well, it's a violation of procedure of law. He cannot do it. I will go on this High Court on this issue also. Or where he doesn't bother about a jurisdictional High Court judgment on a particular issue which is relevant for your assessment, which is paramateria, which is directly the point in your assessment order. I will again go to High Court. Or fifth, some lawyers, senior lawyers do try, and they have succeeded in many cases, which involves a public good. For example, in GST tribunal, we have gone to High Court. High Court is nobody, they can't appoint a GST tribunal. But High Court says, how do you ask him to deposit? He has the right of appeal. So it's all, everything is stayed till GST tribunal position limitation gets extended. So now High Court has not extended limitation of 3 months. They have said that whenever you file appeal, limitation will start at that time because tribunal is not there. So अगर 2 महीने के बाद High Court आप गए थे और 2 महीने का टाइम निकल गया, आपके पास 2 महीने का टाइम हो रहा है ट्रिब्यूनल इंस्टीट्यूट होने के बाद. So on these 6-7 issues, I think in GST law, we can go to High Court if you think this assessment is highly pitched against natural justice, against law passed by a person who has no jurisdiction, and passed against violation of a jurisdictional Delhi High Court or Supreme Court judgment directly on that particular issue, or passed by not by a proper officer, or it's time barred. So whenever you face high pitched demands, before you tell your client deposit 10%, take an opinion. Is it possible to go to High Court? Now, when you go to High Court, there is also an issue. Supposing you do not make a prayer in High Court, my appeal should be deemed to have been taken in time and this period should be excluded. High Court doesn't give you this right, or doesn't pass the order, you don't make a prayer. Then when you come down and file an appeal, I will say, Revenue says, time barred, sir, thank you so much, get out. So whenever you draft a High Court petition also, whosoever lawyer does, such prayers should also be made in the writ petition. If, and the alternatively, I should be directed to file an appeal if my writ is not mentionable. Alternative plea should always be taken, because you're dealing with a time bar situation. If it's declared time bar, then the tribunal will have only limited scope, very limited. There is no merit tribunal can touch in these cases. So only say whether your appeal by FAA was rightly dismissed as time barred. If yes, case is closed. Similarly, if supposing there were no online filing of pre-deposit, you don't deposit a pre-deposit, appeal is dismissed. Then the only scope for the tribunal is to see whether appeal was rightly dismissed in limine. Any other scope? Few tribunals, high courts have indulged into this on some other grounds, but general law is this. So therefore, whenever you come to pre-deposit, and it's a very heavy amount your client can close, don't feel shy to go to any other person who you think knows little better than you. Don't shy to take opinions, because your client will be doomed. If he doesn't deposit, recovery will start. The other question is, this question of pre-deposit for first appeal is very critical. Supposing that demand is 10 crore rupees. On this, Mr. Manmohan Khemka tells you, okay, Sushil Verma, 2 crore you can do nothing. You have to deposit, it's a return tax. So if there is an admitted tax, the words used are admitted tax. Simply you say this is not admitted will not work much. You have to prove why is it not admitted. For example, return का tax आपने जमा नहीं कराया, आपने revised return भी file नहीं की, आपने 99C में भी कुछ उसका नहीं लिखा, तो सारी evidence up to site of appeal is against you. So you have to talk to Mr. Khemka and he tells you, sir, 2 crore तो जमा कराना पड़ेगा. Now 10% is on 8 crore in addition to 2 crores. Now supposing we take a risk, we say no, we will dispute. अब देख लेंगे जो होगा. And tomorrow this question comes up by a government counsel. They say this admit tax not paid, appeal dismissed. I think your all doors are closed. Supreme Court perhaps may intervene, but I doubt Supreme Court will intervene. Supreme Court cannot go against the provision created in a special statute. Next, please. And once you deposit pre-deposit, remaining demand is deemed to have been state. There is no need to move a stay application. It's deemed to have been state. Next. Ritika, next, please. Next, please. We will skip this for this session. Now, stay of demand. In GST law, once you complete the pre-deposit of 10%, all demands are deemed to have been state. Now, these demands that are contained in your order, this order does not affect the right of third parties, duties of third parties. So, for example, मनमोहन खेमका का आरसी कैंसिल हुआ 29/2 का, उसके बेस में मेरे पास 10 करोड़ की डिमांड निकल गई, मैंने जमा कराया, स्टे हो गई. Can we say demand of Mr. Manmohan Khemka is also stayed? Answer is no. But few people have started discussing, but so far the answer has to be a big no, no way, because the stay comes as a consequence of you having filed an appeal as an aggrieved person. If Manmohan Khemka was the aggrieved party, he should have come and filed appeal. He did not file the appeal. So my stay, in my opinion, shall not operate in favor of Mr. Manmohan Khemka, and recovery can go against him. And many people say, no. Cases are pending in High Court. Why should we deposit 10%? Pendency of a case in High Court or Supreme Court has zero meaning in law. Even if a SLP is passed, even if a stay is made against an order, that stay is not in rem. Stay is not a judgment of a High Court or Supreme Court. The stay is applicable only in that particular matter, not in your matter. So be careful when some advocates guide you on these and say High Court leke chalte hain. No. Unless you have a judgment on that particular point, that judgment also you should take to assessing authority, ask them to rectify the order in view of a judgment of a jurisdictional High Court or Supreme Court on a particular point is a ground for rectification or a review. So if you go back to assessing authority, please correct your assessment order. Supposing it doesn't, then you have a right to go to High Court. You need not deposit 10%. Next, please. These rules and forms, I'm not getting into this nitty-gritties. They have to be followed in toto. You cannot deviate from the procedure which that law prescribes. If a procedure has been prescribed, then either you follow or you don't follow. You cannot have it in between via media. Sir, मैंने हार्ड कॉपी फाइल कर दी थी, ऑनलाइन तो आपका बंद था. ऐसे भी हुआ केसेस. ऑनलाइन नहीं ले रहा था, आपका कंप्यूटर बंद था, मैंने हार्ड कॉपी फाइल कर दिया. 4 महीने बीत गए. They say, no, we don't take cognizance of this. Online हमने फाइल नहीं किया. It is declared time barred. You are in a very serious situation because you did not take you took law into your hands by not filing online. That is why people go to High Court and they take direction from High Court and say, okay, online not working, file offline. So if any procedure is laid down, you have to follow it strictly. Next, please. Let's come to a little bit of appeal under GST. We have discussed, but let's quickly go through it. Section 59 says your returns are self-assessment order. As long as these returns are not subjected to scrutiny, for example, ASMT 010, section 61, we will discuss later, or reassessment under any of the provisions of this act, appearance is not required. You don't have to appear anywhere. Once this self-assessment order is put to scrutiny, section 59 is no longer relevant because your returns are no longer a self-assessment order. Somebody has to pass an order accepting or rejecting your self-assessment. Now, in customs duty, there have been many cases where a bill of entry was self-assessed and certain custom duty was paid. During audit, custom duty amount was raised. A point was taken before Supreme Court. No, I went to Superintendent, he cleared everything. Now duty for what? It's not possible. Supreme Court said, no, it's a self-assessment, your self-assessment. So it can all be subjected to audit. अभी कुछ ही प्लेटफॉर्म में चर्चा चल रही थी कि 99C भरने के बाद फ्रॉड कैसे हो सकता है. There was a lot of discussion going in a particular group where I did intervene. I told them this is a very kind of stupid argument. Why not? Does the law prescribe what documents can be gone through to detect a fraud? So if your 99C filed has apparent errors, apparent mistakes, and if it's covered by section 74, it can be invoked. So self-assessment is not a ground that what you have done is everything legitimate and right. It can be subjected to yeah. Now, somebody has put up a question, I'm answering it right here. Section 69, which most of us don't read. If a statute prescribes a mode of service, only that mode can be followed, nothing else. फोन पे नहीं मनमोहन कह भाई मैंने आपको फोन कर दिया कल आ जाना, नहीं आया तो ऑर्डर लिखता, आपको फोन पे बुलाते नहीं आया तो मैंने एक्सपर्ट ऑर्डर पास कर दिया. It's null and void. So section 169 says what are the different means of communicating the notices under GST. Not issuance. Issue is when it goes from the officer. Service is when it's communicated to you. That is called service. Issuance and service, there's a lot of difference. Any other mode of sending on notices will not be valid under law. It says High Court judgment I'm reading, though I'm not quoting it here. Taxpayer. Now, what are the different modes? These are different modes. I'm not going to read them. So, जो भी आपको नोटिस आता है, आपको देखना क्या ये इन 6 पॉइंट में नोटिस मिला था या नहीं मिला था, उसकी क्या रूल्स में क्या प्रोसीजर रिक्वायरमेंट थी, फॉलो हुई या नहीं हुई. If yes, it's okay. If not, please take it a point that notice was not served validly. थोड़ा ऊपर करना रितिका इसको. पीछे पीछे. Yeah, okay. Next. Next. Ritika, next, please.
So just give me a moment, please.
Okay. या इसको आगे ले लो, छोड़ दो इसको. Yeah. Now let us come to what does section 107 says. Each word has a meaning. And whenever you start to sit down and file an appeal, you must read this section every time you draft the appeal, not take it for granted you know everything. Any person. So any person means even a unregistered taxpayer can file appeal. Person defined in section 2. It's a long definition, it's an inclusive definition. So there can be many more persons included in definition of person. So any means Tom, Dick and Harry, not necessarily registered person. VAT में registered person था, यहाँ नहीं है. Any person aggrieved. Aggrieved means where you are hurt, where you think this order passed by the authority affects your rights given by the statute. It enhances your tax liability, or he has taxed you wrongly. You have to prove you are aggrieved by any decision or order. That's why this AMC 10 वगैरह वगैरह जो order pass लोग करते हैं, this is where it comes into play. It's appealable by any decision or order. Order can be 20 orders before a decision is passed. So if you are affected by that order, for example, in 73 proceedings, they attach your bank account under section 83. That's an order passed. Section 73 show cause notice not been disposed of. It's appealable because it says any decision or order. Decision is when finally disposes of the matter and the assessing authority closes the case for or against you. That's called a decision. May appeal is your discretion whether you want to the prescribed first order authority, not any first order authority. So you have to go through the delegation circular against a particular order. For example, if this jurisdiction is based on locational areas or दिल्ली हरियाणा ये जो भी आप करते हैं, जैसे दिल्ली में 10 वार्ड 12 वार्ड 14 वार्ड, आपको उस वार्ड की जो फर्स्ट सबरेट अथॉरिटी है उसी के पास अपील फाइल करनी है और किसी के पास अपील फाइल नहीं कर सकते. टू द प्रेस्क्राइब्ड फर्स्ट सबरेट अथॉरिटी within 3 months from the date on which such decision was communicated. So what is communication in terms of section 169? You have to see whether in terms of section 169 was this order communicated to you. If yes, you have a right to file appeal. The appellate authority may, if is satisfied, may, there is no right available to you that your condemnation will be decided in your favor. There is no right available to you. It is only his may, his discretion, pure his discretion, may, if he is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period of 3 months or 6 months, as the case may be. 3 months for appellant or 6 months for the revenue. Sufficient cause आपको अपनी अपील में लगाना है. क्या sufficient cause था आपका? Supposing आप कहते हैं मेरे पास पैसे जमा कराने के लिए नहीं थे. There can't be a bigger sufficient reason than this. But you have to prove. How can you say you didn't have money? आपकी बैंक स्टेटमेंट जो भी आपके अकाउंटेंट्स आपको गाइड करें उसको करिए, लेकिन जो भी आप ग्राउंड लें बहुत सॉलिड लें ताकि वो उसमें कोई झूठ नहीं निकलना चाहिए. There should be no perjury to this kind of authorities. Allow it to be presented within a further period of 1 month. Now this is where we say Section 5 of Limitation Act cannot be invoked. Section 5 of limitation can be invoked in any statute where it has been invoked by reference that the delay can be condoned as per Section 5. That's an unlimited. But where the condonation delay has been restricted by a special statute like GST, Section 5 shall have no role to play under any circumstances. I know a Calcutta High Court judgment, single judge, where a person was strict there to condone delay. But I don't think that was a good judgment. I can comment because Supreme Court is against this. But that judgment will be tested. They have filed an appeal. Let's see what the Supreme Court says. But so far, Supreme Court is clear. Under such circumstances, the appellate authorities cannot condone delay beyond the period given to them under the law. Next, please. Now, these are some judgments on aggrieved party. I have told you, take the first slide. I'm reading this. Prefer an appeal from such decree order if he is either bound by the order or is aggrieved by it or is really affected by it. For example, 29(2) cancellation of registration of Manmohan Khemka. My assessing authority is bound by that order. He was not registered on the date when I purchased goods because its certificate has been cancelled. So I am bound by the order, therefore I am aggrieved. It affects my right. Therefore, I can file appeal even against order passed in the case of Mr. Manmohan Khemka. Next, please. Again, these are the forms which you have to follow. Hard copy देनी है आपको 7 दिन में, नहीं देनी है, वो सारे procedural technicalities हैं, वो आपको follow करना है. Next, please. We will not waste time on this. Now, this is what Supreme Court says. I will just read this red paragraph. Now, what is the test to find out when it would be proper to grant leave to appeal to a person not a party to proceeding against the decree or judgment in such proceedings? When we say decree or judgment, I personally think it is equally applicable to decisions. We think it would be improper to grant leave to appeal to every person who may in some remote or indirect way be primarily affected by a decree or judgment. We think that ordinarily leave to appeal should be granted to persons who, though not party to the proceedings, would be bound by the decree or judgment in that proceeding and who would be precluded from attaching correctness in other proceedings. अब मनमोहन खेमका का आरसी कैंसिल हुआ, अब तुल्या जान चला गया, नहीं जी ये तो डिपार्टमेंट ने गलत किया, पैसे कैसे कर सकते हैं, जो सबका कैंसिल कर देंगे. He is nobody. But if Mr. Verma's case, his invoices have been issued to me, I am entitled to interest credit, I am directly covered by such judgments, which says I am an aggrieved party. Therefore, his order I can also attack as a party because it directly affects my rights. Next, please. Now, this slide is the most important slide for filing a first appeal. बड़े लोग इसमें गलती करते हैं. मेरे पास कुछ अपील्स हैं जहां लोगों ने गलतियां की हैं, जो ड्राफ्टिंग के लिए चेक करने के भेजी गई, वो ड्राफ्टिंग ही गलत थी because they did not follow what is the adjudicating authority. It means any taxpayer or non-registered person aggrieved by a decision passed by an adjudicating authority. Adjudicating authority defined in the Act, subsection 4 of section 2. Adjudicating authority under GST is an authority. That is your authority. Like proper officer, a proper officer, here also the words, the Batra used is an. Appointed or authorized to pass any order or decision. So order or decision are taken from section 107 under GST Act, but does not include the Central Board of Indirect Taxes and Customs. अगर ये कोई order pass करते हैं, circular pass करते हैं, इनकी आप appeal file नहीं कर सकते. The revisional authorities, section 508 में आपका revision किया गया, summary revision किया commissioner द्वारा in any form mentioned therein. His order you cannot take as first order authority because he is not an adjudicating authority. The authority for advance ruling, because there is an authority of appeal, the appellate authority for advance ruling. अब वहां जाओ, first order authority में नहीं जाना. The appellate authority may appeal to appellate authority within 3 months. So ये जो भी order आपके सामने आता है, पहले आपको देखना है क्या जिसने order किया है, is he not covered by the exceptions of this adjudicating authority? If he's covered, then you have a problem. First appeal cannot be filed because the order is not passed by an adjudicating authority. Next, please. These are non-appellate orders. इनका आप ऑर्डर पास नहीं कर, अगर ये ऑर्डर पास करते हैं आप अपील नहीं कर सकते. अपील हाईकोर्ट रिट की हम बात नहीं कर रहे. An order of commissioner or authority empowered to direct transfer of proceedings from one officer to another. Supposing you smell bias, you can approach High Court. If this fellow is against me, इसने पहले मेरे ऑर्डर पास किए, मेरे से झगड़ा किया है, मैंने इसकी शिकायत की है, ये रिश्वत लेता है, जो भी आप लिखना चाहते हैं, but not an appeal. An order pertaining to seizure or retention of books of accounts, register and other documents, it's not applicable to search and seizure of stocks. It's only applicable to seizure or retention of books of accounts. So section 67, search seizure of stocks, is not covered by non-appealable orders. An order sanctioning prosecution, section 132, that is 69, an order passed on section 80, payment of tax in installments. जो 4 ऑर्डर सेक्शन 121 बोलता है, इसकी आप अपील फर्स्ट अथॉरिटी को फाइल नहीं कर सकते, दे आर नॉन अपीलेबल ऑर्डर्स। तो अगर फर्स्ट अपील में नहीं है तो ट्रिपल में भी नहीं है, बात ही खत्म हो जाती है। नेक्स्ट प्लीज। नेक्स्ट वी हैव डन दिस। Now it's happening against this law, but the law says appellate shall pass a proper confirming so and so, but shall not refer the case back to authority that passed the said decision or order. Section 107, subsection 11. So I will say, as compared to VAT, if this section has not been amended so far, not to my knowledge, there is no remand back. They have to take a call, yes or no. But is it mandatory? My answer is yes. The word used is but shall not refer. Powers are given, you can confirm, modify or annul. ये चीज वैट में नहीं लिखी हुई थी कि but shall not refer the case back to authority. So to cure that chaos, they have written here, it will not go back to the authority that party said this is an order. Now, next is the appellate authority is empowered to pass an order enhancing the fees or penalty or fine, lieu in confiscation or conveyance of goods of greater value reduces so and so by giving you opportunity. He can give you कि बॉस 10 रुपए लगा, 100 रुपए लगना चाहिए था, मैं 100 रुपए करने वाला हूं, आपको कोई जवाब देना है तो दे दो. Now many people confuse this showing cause with a show cause notice. I don't think this is a show cause notice. Showing cause means you are being given a communication. कि look, Mr. Khemka, 100 रुपया लगाई गई है, 1000 रुपया पेनल्टी लगनी थी. If you remember a written Supreme Court judgment of penalty, if there is no discretion, full penalty has to be imposed. Whether it's a tough judgment or wrong judgment, I agree with the judgment. If penalty is mandatory and there is no discretion, there is no discretion. So showing cause doesn't mean कि इसको कोई show cause notice देना आपको. Order sheet भी लिख सकता है आपको. He is only show a cause to you कि look, this is the cause I want to enhance the what fees or penalty or fine, not tax or interest. Now we come to first proviso to section 10711. ये बहुत जरूरी है, ये बहुत बड़ी पावर है इन लोगों को. The FA can also enhance the tax or decide the wrong availment of ITC variance with the proposal in the first show cause notice. पहले शो cause नोटिस में 4 पार्टियों का आपको ITC डिस्प्यूट किया गया. वो कहते हैं नहीं यार सुशील जी, मेरे यहां तो अभी 4 पार्टियां और हैं जिसका आपको डिनाई नहीं किया गया. He can give you a specific show cause notice which is at variance with the first show cause notice. Now, this issue is for High Court to decide because this gives an unending, unfettered power to authorities to go on issuing show cause notice. So that can be now, but the only rider here is the limitation should be as per 73 and 74. That is, अगर 73 के लिए 3 साल का टाइम है, whatever time, I'm just taking example of 3 months, but 3 years, तो उसकी फर्स्ट अपील सुनने को आ रही है 2 साल 11 महीने में, 1 महीना और है, he can issue show cause notice. लेकिन अगर 3 साल बीतल का, he cannot issue show cause notice even if he has information. So this says it can be done only after giving specific show cause notice. That is specific where he is feeling at variance with the first show cause notice to the appellant against the proposed order, and the order itself should be passed within the time limit specified under section 7074. Now there is the second proviso. Next please. So fine, penalty, enhance कर सकते हैं after showing cause to you. Fine, penalty or fine lieu of prosecution. He can enhance by showing cause, then he can give you a second show cause notice which has variance with the first show cause notice on a specific issue, provided the limitations for passing the orders are maintained for the purpose of section 73, 74. Now this section also shows one more feature which intrigues me. Can show cause notice be issued only in section 73, 74? It refers that should be passed within time limit. It doesn't refer कि show cause in section 70, 74. सिर्फ टाइम लिमिट को यहां पर रेफरेंस अडॉप्ट किया गया है. तो शो का नोटिस और बड़ी चीजों के लिए हो सकते हैं. नेक्स्ट, इसका नेक्स्ट प्लीज. Is it over? Okay. But now take the other file very quickly. I think we can finish it.
Shall I start with the Word file?
Yeah. No, इसको नहीं, ईवी बिल को बाद में लेना बिल्कुल.
Which one has to be taken, sir?
First take LN. Yeah. Now, this is a notice which we are giving to all the professionals. Wherever you have a problem in claiming input tax credit on any ABC reason, and the reasons are attributed to the supplier, other than filing appeal and all that stuff, to the extent input tax credit denied to you, you remain an unpaid seller. Therefore, you must put him to a notice. कि बड़ी ये आपने हमारा माल खरीदा था, आपने रिटर्न नहीं भरी, टैक्स जमा नहीं किया, आप चोर डिक्लेयर करेंगे, जो भी करेंगे, मेरे पैसे दो आप. Now, supposing you go on contesting appeals, 3 years are over. The list is time barred. Unless we are able to make the list will start from the assessment order. My opinion is different. List will start from date of invoice, not from date of order in your case. So, जैसे ही आपके लिए झगड़ा होता है, type this notice, fill in the blanks करो, आपने वकील लोग लेटर हेड पे आप उस क्लाइंट को भेज दो कि बड़ी ये पैसे आपको देने. So you have time to file a case. It will involve stamp duty to recover the amount. So therefore, it's a very good opening for lawyers to diversify into this area, and this legal notice is fairly good for all purposes, for the purpose of recovery of GST law. This copy is coming to you. For example, para 4 I am reading. For all the tax invoices, as per annexure 8 to this legal notice, you have neither shown these invoices in your returns nor deposited the GST that you have charged, and my client paid as per due process of law. This has now resulted in denial of input tax credit to my client, and to this extent, my client has been prejudiced and has been suffering financial injury. While we do not know the reasons for non-deposit GST, nor we are informed by you or your team about such. Yes, Sujit Sarkar, we are sharing the format. Don't worry, you'll get it. While we do not know the reasons for non-deposit GST, nor we are informed by your team, we now request to deposit GST up to date as per law by so and so, failing which, by which means maximum 16 for limitation. उसके बाद आपको मिलने वाला नहीं है. Under instruction, legal action will be initiated, both civil and criminal, as may prescribe the client. Please note that you must deposit so and so. Now, this is a kind of a legal notice which all GST advocates at least should get into, and they should help their chartered accountant friends to type on their letterhead, send on the behalf, I will say without charge. So this is another diversification issue that brings GST to our profession. Next file, please, Ritika. Condonation. Now, I'm only giving you affidavit. Now, so इसमें दोनों है, आपको affidavit भी है, इसमें condonation भी है. इसको आगे करेंगे जरा. बस थोड़ा पीछे करिए. ये जो affidavit आपको फाइल करना है, इसमें ये आपको फैक्ट जरूर लिखने हैं. I'm not repeating. I think this is a very general affidavit. Therefore, you have to annex this affidavit with the application. Now move the application, Ritika. इसके अगले बेटा application होगा. देखो जरा. इससे आगे होगा इसी पेज में. या चलो आगे चलो. Good. Just read para 3. That the delay in filing so and so appeal is neither intentional nor willful, but due to good and sufficient reason shown herein above. अब ये आपको गुड रीजन बताने हैं, क्या रीजन थे कंडोनेशन डिले के. ऊपर आपको लिखना है कि आपको अपील कब तक फाइल करनी थी, कब आपने फाइल की, कितना डिले है, ये आपको लिखना है. कोर्ट को नहीं पूछना आपसे. You have to go with clean hand. अगर यही फंस जाते हो तो कोर्ट गेट्स वेरी एंग्री के you don't know how to draft an application. भाई आप कहते हैं इंप्रिम्ड ऑर्डर आपके पोर्टल पे एक को आया, आप बोलो जी मुझे 31 मार्च तक और 3 महीने में अपील फाइल, 3 महीने नॉट 90 डेज, द 3 months, मंथ्स मींस ए कैलेंडर मंथ, आपको 31 मार्च तक अपील फाइल करनी थी, आपने नहीं की, अब आपका कंडोनेशन है, आप कहते हैं मैं 20 दिन के बाद कर रहा हूं, तो आपका डिले 20 दिन है, 3 महीने नहीं। वो आपको डेट लिखनी है, फिर उसको रीजन लिखना है कि 20 दिन में आप क्यों अपील नहीं फाइल कर सके। पैसे नहीं थे, आप बीमार थे, आप आउट ऑफ इंडिया थे, आपके घर में कोई हादसा हो गया था, कोविड था, कोई बीमारी थी, कोई इमरजेंसी, जो भी आप लिखना चाहते हो, but that has to be corroborated by evidence to be annexed with this application. That is very critical. Don't jump at this controversial bit. There are cases where even Supreme Court has refused to condone delay. There's a case of Postmaster versus Union of India, where Supreme Court lambasted government कि फाइल में रह गई थी, वो फाइल घूम रही थी, there are no reason to be dismissed. Living Media is another case where government appeals were dismissed because they could not explain the delay sufficient reason. So reason आपको बहुत ध्यान से लिखने हैं, और फिर लिखना है कि अगर ये आप डिले कंडोन नहीं करोगे, it will cause me injury and therefore my delay should be condoned. This format is also being shared. रितिका, इसके बाद ले लो रजिस्ट्रेशन डॉक्यूमेंट। या ये दिल्ली में खारी बावलों को काफी नोटिस आते हैं, जो लोग सिर्फ टैक्स फ्री गुड्स में डील करते हैं। यहां नॉन टैक्सेबल गुड्स में, फॉर एग्जांपल लिकर, पेट्रोलियम प्रोडक्ट्स, और वो कुछ डील नहीं करते, उसमें कुछ डील नहीं करते, उनको भी नोटिस आते हैं। उस नोटिस का सर आपको जवाब देना है। नेवर इग्नोर ए नोटिस दैट कम्स फ्रॉम गवर्नमेंट। You have to file reply, take acknowledgement if required online. You have to file reply online without fail. Now, these are few cases which I have taken. If you get these kind of notice, what do you write? You write, जो भी आपका ऑफिसर है उसका डेजिग्नेशन, जो भी उसका नाम शाम है, उसका जो नोटिस है लिखिए that is response to notice so and so, that you notice you have stated that you have information that we are liable for registration on the ground that we are dealing in taxable supplies and not fully exempt supplies. GST में उसको पावर है कि he can suo motu decide your liability whether you apply or not. आपकी दुकान पे गया, दिख रहा है कि खोया हुआ बेच रहा है, जब टैक्स नहीं देता आप नंबर लो। In this connection, there are 3 more extensions which I think are common, so I've taken them. We'll read them. In this connection, we wish to inform you that we are dealing in the following goods only. आप goods लिखो, किन goods में आप डील करते हो। These are exempt from GST under Section 9 or under various schedules or notifications issued. वो आपको रेफरेंस देना है, एंट्री की रेफरेंस, नोटिफिकेशन का नंबर, कौन से शेड्यूल में, और वो क्यों टैक्स एग्जम्प्ट है, आप उसमें डील करते हैं। We are also enclosing a duly sworn in affidavit in this respect. आपको एफिडेविट देना है, हम और कुछ डील नहीं करते, हम इसके अलावा और कुछ नहीं बेचते। We are not dealing with any tax supply of goods. We are attaching with this reply an extract of notification so and so, clearly stating that goods we deal are tax exempt. Hence, we are not required to apply registration as per provisions of law, that is Section 22 of the DGST Act or CGST Act. तो ये अगर आपको पहला नोटिस आता है, ये एसेंशियल पैराग्राफ्स हैं, आपको जो लिखना चाहें जरूर लिखें, लेकिन ये एसेंशियल है। इससे आगे लीजिए आप। In this connection, please note that we are dealing in resale of liquor for human consumption or exclude dealing petroleum products on which no notification. Now, petroleum products are not tax exempt; they are taxable in GST law. Many people have petrol में tax नहीं लगता, taxable है. Only the date of taxation has been deferred in Section 9. They are remain taxable, but the tax liability cannot arise because the date has not been notified by the GST Council. And hence, as per legal advice given to us, we are not required to be registered under GST. It's always better when you file this reply, take annex a legal opinion taken from a professional. Yes, we had done the due diligence, we did not take registration because we were advised इसमें आपको नंबर लेने की जरूरत नहीं है. We're enclosing an affidavit respect clearly stating that we are not dealing with so and so, and hence notwithstanding our aggregate turnover being above 40 lakh, we do not require registration. So Section 22 says if your taxable supply is more than 40 lakhs, if you say your supply itself is not taxable, there is no question of Section 22 getting invoked in your case. Also, we are enclosing a certificate from CA. ये कुछ evidence clinching होती है. CA को कुछ पैसे देने पड़ेंगे, कोई प्रॉब्लम नहीं, but you will be able to finish the case right here. वो CA लिखेगा भाई इनका मैंने बैलेंस शीट देखा है, बुक्स देखा है, मैं ऑडिटर हूं इनका, ये और किसी में डील नहीं करते. तो जो आपका जो रिप्लाई उसके पास गया नोटिस के खिलाफ वो सेल्फ कंटेन्ड है। अब इसके बाद वो क्या पूछेगा? हाँ, इफ ही हैज एनी रिपोर्ट्स अगेंस्ट यू देन ही हैज टू गिव यू शो कॉज नोटिस। द लास्ट वन इज we start the business so and so and we deal in and so far we have made supply to 15 lakh well below the tax requirement of 40 lakh that requires compulsory। कहते हैं हम टैक्सेबल का हैं पर हमारे अभी 40 लाख के टर्नओवर नहीं हुए, हमें नंबर लेने की जरूरत नहीं है। And also right to we have not suffered any liability under section 24, so if you violate any of the conditions of section 24 read with certain notification then you have to take registration notwithstanding your turnover is 40 lakh or below। तो वो भी आपको ध्यान रखना है। ये तीनों केस में जो रजिस्ट्रेशन केसेस हैं, 3-4 केसेस हैं, इस तरह के जवाब आपको सिंपल से बनाने हैं, इसमें कोई कानून की जरूरत नहीं है। बट the evidence that you have to enclose that should be proper। अगर सीए सर्टिफिकेट की जरूरत है, don't hesitate to enclose सीए सर्टिफिकेट कि वो सीए 5,000-10,000 मांगेगा, आपको देने पड़ेंगे। अपीलों में फिर लाखों रुपए लगेंगे। Once he doesn't agree with you, he will ask you to file returns। वो लंबी प्रोसेस है। नेक्स्ट। Yeah, now you can take the Vineet file, VNT, this one. Now these are ASMT 10 issues. I have given you a very detailed, whatever points were told to me by people, किस point पे ASMT 10 आता है. 61, 62, 63, all you have to read together. 63, 61, 3 में उसको बहुत बड़ी power है. We are not discussing the law here, therefore I'm not getting into it. But if you get ASMT 10 issues, this is a beginning of your litigation. वहां आपको ध्यान रखना है। अगर यहां मार खाते हैं, लिटिगेशन लंबा होगा। फिर वही बोलेगा जो पॉइंट हमने पहले नहीं लिया था, मैं नहीं मानूंगा, ये नहीं करूंगा, वो नहीं करूंगा, वो सारी एप्लीकेशन आपको मूव करनी होगी। The applicant registered under GST and so and so, ये हमेशा आपको लिखना, हर अपील में आपको लिखना है बिफोर सो एंड सो इन द मैटर ऑफ सो एंड सो जीएसटी नंबर एंड अपील अंडर सो एंड सो। आपको लिखना है जीएसटी में रजिस्ट्रेशन है हमारा, हम क्या बिजनेस करते हैं, ये बिजनेस आपको लिखना है। ये हम बहुत लोग नहीं लिखते। You have to write, I'm engaged in the business of so and so, and appeal is being filed through a proprietor, partner, or a director, or a trustee, or a karta, or an LLP, whatever various forms of organizations you have. The appeal is being filed by a duly authorized person. ये लिखना जरूरी है। So it's a very technical thing, but you write, it avoids any doubt. Is within limitation period, and so, and a mandatory period about 10% of dispute has been deposited. ये जो तीन चीजें अफसर ने देखनी है, तीनों आपने क्लियर कर दी कि जी मैं अग्रीव्ड हूं, अथॉराइज्ड पर्सन अपील फाइल की है, लिमिटेशन में की है, 10% जमा करा दिया, एक पहले झगड़े आपके खत्म हो गए। The applicant has filed all the due returns, वो भी आप लिखते हो रिटर्न फाइल की है, जो मेरे हिसाब से सेल्फ असेसमेंट टैक्स बनता था एज पर सेक्शन 59, मैंने वो टैक्स जमा करा दिया है। Therefore, it's my self assessment order। इसके ऊपर करेंगे बेटा। So I have drafted in the form of an appeal, but you can also use this for filing a reply to ASMT 10. So this particular note of 8-10 pages is covering both. The proper officer has sent ASMT 10 giving me time up to, which is a mandatory time of 30 days. अगर उसने 30 दिन से टाइम आपको कम दिया है, he cannot give. 30 दिन का टाइम उसको देना है। You take this point, if you not taken before the proper officer, take an appeal कि मुझे टाइम नहीं दिया है क्या, therefore this order is non-est। या आप हाई कोर्ट जजमेंट आ चुकी है, ये टाइम आपको देना है। ASMT has been issued on the following grounds। अब ये हम लोग बहुत गलती करते हैं जब लोग अपील ड्राफ्ट करते हैं, हम समझते हैं कि वो अथॉरिटी सारा पढ़ेगी, बारे को क्यों टैक्स लगाया गया। नो, that is not an art of drafting appeal। The content of your appeal should say on what issues you have been taxed। फॉर एग्जाम्पल 10 इश्यू थे, आपने 10 इश्यू पे अलग अलग लेना है कि आपको इस इश्यू पे टैक्स लगाया गया है। उन इश्यूओं को आपने रिबट करना है अपने ग्राउंड ऑफ अपील में, तो 10 ही आपके ग्राउंड ऑफ अपील बनेंगे। लेकिन जब आप इश्यू नहीं लिखते और खाली अमाउंट लिख देते हैं, वहां थोड़ा कंफ्यूजन होता है इवन व्हेन यू आर्ग्यू बिफोर द अपीलेट अथॉरिटी। सो फॉर एग्जांपल एएसएमटी पे कहते हैं कि आपने 4 लोग थे जो नॉन फंक्शनल थे, बोगस से आपने 50 लाख का आईटीसी लिया फर्स्ट ग्राउंड। सेकंड कहता है कि आपने जो प्रोडक्ट क्लासिफाई की वो HSN था, हमारा HSN USO है, आपने 8% कब टैक्स में कराया, देयरफॉर आई चार्ज यू इंटरेस्ट एंड पेनल्टी. देयर कैन बी अ थर्ड इशू, आपको TDS काटा था, आपने TDS नहीं काटा. फोर्थ इशू, आपने RCM नहीं जमा कराया, आपने क्यों नहीं जमा नहीं कराया. तो ASCMT 10 is a notice which the revenue is taking like a बेलगाम का घोड़ा. They issue on anything because this is based on verification of your returns. I for one do not agree with the view of people that there the inquiry scope is limited. No, return verification is a big issue, and that is the list of your tax dispute with the authority. So ASCMT 10 is very big notice. सारे जो शोकॉज नोटिस वो ANC 10 से फ्लो करेंगे बाद में आपके पास if it is issued. The so and so AS has been issued on the following grounds. आप grounds दीजिए next please. If the tax were received intimating, अब पहला ग्राउंड क्या है आपका, GST 1 और GST 3B के झगड़े हैं, राइट? पहला सबसे बड़ा झगड़ा आपका यही है. The proper officer raised this issue that the ITC claimed by appellant is not matching with the details of outward supplies reported by supplier. Notwithstanding the fact that appellant in possession all documents and payment details, including proof of physical so and so or so and so. Still, based on the non-reporting of bills by the officer has raised. Yeah, Mr. Sagar, I'll tell you later whether you can share on Google. My answer is no. We don't sell knowledge. Still, based on the non-reporting of the bills by supplier in GST 1, the officer has raised the discrepancy and has virtually passed the order asking the appellant to deposit tax and accept. Now, here we take Supreme Court ruling. That's latest one ecom. उसको पढ़ना है आपको, वो GST में डायरेक्टली रेलेवेंट है, इस पे कोई डाउट की बात नहीं. Quest marketing judgments, the Supreme Court didn't agree. They say because a provision like section 70 which says onus is upon you to prove was not discussed in that judgment. Similarly, we have section 155 and section 55 of GST is much more imperative, much more serious than section 70 of CAVM Act. Section 155 deals with only input tax credit और उसमें कुछ नहीं लिखा. All other claims you don't have to prove. Input आपको claim करना है, आपको prove करना है. So ecom की judgment को ज्यादा लाना है. Not that judgment is directly relevant, क्या उसमें कोई 16(2) जैसा provision वहां नहीं था. हमारे यहाँ 16(2) की सातों condition आपको satisfy करनी है. Because 16(2) deals with a notwithstanding clause. Once a provision starts with a notwithstanding clause, anything contained in the section, that section overpowers all other sections. It has no connection with 16(4). 16(4) deals on a very different tangent. Section 16(4) deals with limitation. It doesn't affect your rights of ITC 16(1) and 16(2). 16(2) जो में कंडीशन है वो आपके ITC की है. अगर वो कंडीशन आप सेटिस्फाई करने हैं तो 30 नवंबर अक्टूबर जो भी डेट है तब तक आपको ITC की क्लेम करना है. तो 16(4) और 16(2) में किसी तरह का कोई लिंक नहीं है मेरे हिसाब से. Though I have filed 3 writs, have taken the stay orders, but I know I'm going to lose. I have no doubt about it, we will lose. तो 16(4) का 16(2) से कोई लिंक नहीं रहता. तो आपको बताना है, इस जवाब में लिखना है कि हमारे पास सारे डॉक्यूमेंट है जो ईकॉम के सुप्रीम कोर्ट ने लिखा है. आपके पास ई-वे बिल्स हैं, एक्नॉलेजमेंट हैं, फिजिकल डिलीवरी का प्रूफ है, आपने पेमेंट की है, आपके सप्लायर के एड्रेस हैं, उनके पार्टनर के पैन कार्ड हैं, पार्टनर डीड हैं, जो भी आपके पास है सब लिखवा रहा हूं इसमें. The appellant was aggrieved by the notice and name the editorial price will be signed so and so. Now इसके बाद भी उसने आपने सेक्शन 73 74 का आपको नोटिस उसने इश्यू कर दी. ASMD वेरिफिकेशन के बाद वो कहता नहीं मैं आपकी बात नहीं मानता. I want to recover the amount. Then we say how do we file the appeal. Next please रितिका आगे चलाएंगे. आगे चलाएंगे या ओके ओके बस. हाँ, the appellant had filed a detailed reply before the proper officer of all the allegations, though unsubstantiated. They only want drafts. They don't want to hear. Am I right, Rahul Kant? We will share the draft. Manmohan Khemka will share the draft with you, not me. but the officer did not pay any heed to the explanation, legal cases and documentary evidence placed by the applicant before him and ultimately passed the assessment order. अब ये क्या होता है, जब ये ग्राउंड हम नीचे नहीं लेते तो क्योंकि हम नेक्स्ट अपील भी आप इसी की बेस पे बनाएंगे, आगे भी नहीं लेंगे, तो दिस केसेस में केसेस डिबेटेबल हैं, राइट फ्रॉम डे वन यू हैव टू मेक ए क्वेश्चन ऑफ लॉ. अगर आप क्वेश्चन ऑफ लॉ नीचे नहीं बनाएंगे, ऊपर नहीं बनेगा आपसे, हम फैक्ट्स में उलझ जाएंगे वहां जाके. तो हमेशा आपको एक पैरा जरूर लिखना है कि दिस इज अगेंस्ट लॉ, वट एवर क्वेश्चन ऑफ लॉ आपको करना है, और ये फैक्ट्स के बेस पे करना है. मेरे पास सब कुछ है, आप इसमें अराइज इंडिया लगाएं, गेरूमाल लगाएं, जो सी मर्जी जजमेंट लगाएं, मेरे हिसाब से वो जीएसटी में उनकी कोई रेलेवेंस है नहीं. द एसएम रिटर्न वाज इशूड ऑन फॉलोइंग ग्राउंड्स. आप अपील में लिखिए किस ग्राउंड पे आपको एसएम इशू किया गया था. अब यहां अगर पॉइंट लेना चाहें, इफ सम पीपल वांट टू टेक, हैज ही गॉन बियॉन्ड सेक्शन 61, सपोजिंग यू आर कन्विंस्ड के सेक्शन 61 का एक लिमिटेड स्कोप है, व्हिच अकॉर्डिंग टू बी नो इट हैज अनलिमिटेड स्कोप, तो उसमें आप लिखिए कि दिस ऑल इश्यूज are beyond the scope of section 61. Therefore, the proper officer had traveled beyond his jurisdiction, beyond his powers given in section 61. ये point आपको यहाँ लेना है, कहने से बात नहीं बनी, आपको लेना है. And why so? You have to write so. Next, please. Ritika, next बेटा. Yeah. शोकास का नोटिस लिखिए वगैरह. And on the following grounds, आपके क्या grounds हैं? Grounds आपने बहुत बड़े नहीं लेने. अगर 3 इश्यू, आपको 3 इश्यू डिस्कस करने, आपको 6 इश्यू डिस्कस नहीं करने. दैट्स नॉट ए गुड ड्राफ्टिंग ऑफ अपील. खामाखा की बातें, जो जजमेंट देखी वहां लिख देते हैं, 25-30 जजमेंट लिख दी, तो आंसर इज यू हैव ऑलरेडी लॉस्ट द केस. आपको वही जजमेंट लगानी है विच इज डायरेक्टली इन प्रोपोर्शन टू द केस यू आर डीलिंग विद, रेलेवेंट टू योर फैक्ट्स. ये मत लिखो उसमें लिखा था कि अच्छा नेचुरल जस्टिस में ना टैक्स लग सकता, हम लगा देते हैं, और उसने आपको ASMT 10 दिया है. It may be deficient or improper, that's a different thing, but it is there. However, the appellant submit as it was issued on the following limited grounds mentioned briefly. From the above, it's clear that a conjoint reading of section 61 read with 7074. Now, this is the legal question we are making. This is the legal issue we are debating. Read with section 74 is debatable whether SC issued can travel beyond ASMT return, more so when reading 61, which is the key substantive provision section 61. Only scope of scrutiny is verification of data claimed in return based on available information available with him at the time of when his returns are scrutinized. Question is, वो रिटर्न वेरिफिकेशन किससे करेगा आपका? जो डाटा उसके पास अवेलेबल है. अब ये जो इंफॉर्मेशन वर्ड है, ये इज नॉट डाटा अवेलेबल ऑन पोर्टल. ये में हैव इंफॉर्मेशन कि आप चोरों से डील करते. So if we limit the scope of 61 only to the data available on portal, that will be demeaning the power of the proper officer to investigate the matter, to verify the returns. He said, जो data claim आपने return में बनाए हैं, based on available information, the law doesn't write on the portal, on the computer or communicate it. No, law is not writing this. With him, जो information available है, उसको आपके पास share करना है. अगर उससे आगे चलता है, then we have a question of law. ये इंफॉर्मेशन सारी हमने जवाब दे दिया. अब जब ऑर्डर लिखता है वो कहता है नहीं आप तो वो उनसे भी डील कर रहे थे, वो तो चोर है, उनके आधार से कैंसिल हो चुके थे. नाउ कैन वी से, कैन ASMT 10 travel beyond the inquiries he has made, whether based on portal data or the information available with him? Can he go beyond this? That is a question of law we have to think and make. He perhaps cannot. Then you take legal grounds. तो पहला अपील को आपको लिखना है कि आप हम GST रजिस्टर्ड हैं, हमने रिटर्न फाइल किया, हमारी अपील टाइम पर है, हमने प्री डिपोज जमा कर दिया, अपील ऑथराइज्ड सेक्रेटरी ने फाइल की गई है. नेक्स्ट पैरा आपका फैक्चुअल मैट्रिक्स क्या है, आपको किस बात के लिए टैक्स लगाया गया है, और आपके पास आप क्यों उससे अग्रीव्ड है, तो आपको लिखना है यू हैव टू मेक यू आर अग्रीव्ड. देन लीगल ग्राउंड्स कि लॉ में क्या पोजीशन है आपके हिसाब से, क्यों टैक्स लगाया गया. कहते हैं that the proper officer cannot unilaterally seek payment of tax without probating the opportunity of being heard for ascertaining reasons for non-payment, short payment, erroneous fund. So 73-74 deals with only three specific reasons. There cannot be any fourth reason when you invoke section 73-74. I'm not discussing any other section of the act. If you have short paid, not paid, you have made a wrongful claim in particularity, or you have given a wrong refund, you have claimed a wrong refund. Section 7.3, if it was not done, if it was not done with intention to fraud or willfully misstatement or suppression of fact. Fraud एक्ट में डिफाइंड नहीं है, विलफुल मिसस्टेटमेंट डिफाइंड नहीं है. सर्विस टैक्स में सुप्रीम कोर्ट की बहुत रूलिंग है इसके ऊपर, शायद मैंने कहीं दी भी है, मुझे याद नहीं है. और सप्रेशन ऑफ फैक्ट, ये बहुत खतरनाक फ्रेज है. सप्रेशन ऑफ फैक्ट 74 टू एक्सप्लेनेशन 2 डिफाइंड है. अब यहां जब 61 को अब से लिंक करते हैं, हम समझ जाते हैं कि 61 की पावर अनलिमिटेड है. 74 टू डजंट टॉक ऑफ रिटर्न, इट टॉक्स ऑफ एनी स्टेटमेंट और एनी अदर डॉक्यूमेंट कॉल्ड फॉर. अगर आपने इसमें रिटर्न आपने शेयर करनी थी, आपने नहीं की इंफॉर्मेशन, एंड दिस इज डीम्ड टू बी ए सप्रेशन ऑफ फैक्ट. अब इसको कल को कोर्ट क्या बोलेंगे हमें नहीं पता. सो फार दिस केस आर नॉट गोइंग टू एनी हाई कोर्ट, बट आई डोंट थिंक हाई कोर्ट कैन गेट अवे फ्रॉम इट कि हम इसको नहीं मानते, मानना पड़ेगा. सो वंस ए फ्रेज इज डिफाइंड इन अ स्टैट्यूट, यू कैनॉट चेंज द मीनिंग ऑफ द स्टैट्यूट. फ्रॉड नहीं है, फ्रॉड भी नो, चाहे वो कॉन्ट्रैक्ट एक्ट ले लें, आपने हमारे कस्टमर सर्विस टैक्स में बहुत डेफिनेशन है. विलफुल मिसस्टेटमेंट 74 basically deals with intention to await willfully. That is the phrase of section 74 तीनों चीजों के लिए. बस सप्रेशन ऑफ फैक्ट क्योंकि डिफाइंड है, उससे अगर आप सेक्शन 61(1) को लिंक करते हो, 61(3) को लिंक करते हो, तो पावर अनलिमिटेड है इन माय व्यू. नेक्स्ट प्लीज. Under both the provisions, SCN can be issued only for non-payment of tax, short payment, erroneous refund. तो अगर वो 73 को इन्वोक करता है, ASMD 10 के बाद जो बकवास करने के बाद, he cannot go beyond section 73, 74. So that interplay of 61, 74, explanation 2, 74(2) to explanation, and 73, 74. ASCM 10 में इसमें कुछ भी लिखा हो, आपके कुछ भी आपके साथ खिलाफ लिखा हो, लेकिन जब वो 73, 74 में शो का नोटिस इशू करेगा, 3 ग्राउंड है, चौथा ग्राउंड अवेलेबल नहीं है. तो here is scope of issuing a show cause notice under these provisions is very limited. Only to these 3 issues. There cannot be 4th issue. Like I've written, from the cursory reading of SCN 10 SCN issued under the above provision, it's clear that SCN is very vague and there is no finding given. अब ये जो हम जब शो का नोटिस पढ़ते हैं और उसका जवाब बनाते हैं, कम से कम 2-3 दिन लगाने चाहिए आपको शो का नोटिस को पढ़ने के लिए. लास्ट पैरा मत पढ़ो, टैक्स लगा दिया, वो जवाब नहीं है उसका. शो का नोटिस में उसको प्रूव करना है, वो दिखाना है कि ये पॉजिटिव एक्ट है कि आपने टैक्स जानबूझ के नहीं दिया इवेट करने के लिए, आपने रॉन्गफुल आईटी से क्लेम किया झूठ बोलकर, और आपने रिफंड गलत क्लेम किया झूठ बोलकर. ये उसको पॉजिटिव एक्ट दिखाना, एविडेंस देनी है आपको साथ कि इसलिए मैं मानता हूं. फॉर एग्जाम्पल, लेट्स से certain RCs of dealer were cancelled and notified. Let's say I'm not talking of GST. अब नोटिफिकेशन के बाद भी अगर आपने सेल की है, this deemed to be a willful destruction of evidence. This is suppression of fact. अब उसमें आप कह रही हैं हमको कैसे पता? Once it's gazetted, it's supposed to be, you're supposed to have a knowledge. It's a law. If show का notice is vague, वो कुछ पॉजिटिव एक्ट नहीं करता, तो आप ग्राउंड लेना है कि आपका शो का नोटिस will not stand the scrutiny of law. It's very vague. There is no evidence, no positive act given to me. Why is it my returns you find wrong? Why are you invoking section 74 or for section? आपको दोनों ग्राउंड लेने हैं, क्योंकि अगर 74 का नोटिस खत्म होता है, 73 में ऑटोमेटिक पहुंच जाते हैं, प्रोवाइडेड देयर इज अ लिमिटेशन. अगर 74 का नोटिस उनको आपने 1.5 साल में दे दिया, 1 साल के बाद वो 74 का ड्रॉप कर देता है, उसके बाद 6 महीने हो रहा है 73 को डिस्पोज करने के लिए, the notice gets converted automatically to 73 as per law. Petitioner has further urged that impugned SCN does not contain any foundational facts such as allegations of fraud, willful misstatement, suppression of fact, which are sine qua non for the assumption of jurisdiction. So the jurisdiction under section 73, 74, which is nothing but a reassessment in a layman language, is conditional. The original proper officer, his jurisdiction is inherent. वो 61 में कुछ भी कर सकता है, वो आपको इस माय व्यू, वो जो मर्जी आपसे मांगे आपको देना होगा, जो आपने रिटर्न में क्लेम किए हैं. There can be no ground of not giving it. Otherwise you should होगा नोटिस, कुछ भी लिखे. But section 73-74 is a conditional jurisdiction. अगर उसको 73-74 का jurisdiction देना है तो जो कंडीशन 3 लिखी है उसमें उसको थ्रू ए पॉजिटिव एक्ट फाउंडेशन बनाना पड़ेगा कि कैसे 74 उसने इन्वोक किया. अगर आपके विजडम में वो नहीं बना तो आपको कहना है दिस नोटिस हैज नो लेग्स टू स्टैंड, इज वेक, एंड देयर आर मैनी सुप्रीम कोर्ट रूलिंग्स ऑन दिस पर्टिकुलर इशू. पीछे लो अभी नहीं, अभी ऐसे नहीं. हाँ. अब द proprietor has issued DRC 01 to petitioner. DRC 01 is a letter before show cause notice. Am I right, Manmohan?
Sir, it is a summary of the show cause notice.
Yes.
So it has to succeed the show cause notice. It cannot, it shall not precede, in my view.
DRC 01 is issued first after show cause notice issued. This
Yeah.
is not a show cause notice.
This is not a show cause notice.
तो अगर ये DRC 01 आपको 4 महीने पहले इश्यू कर दिया, 3 महीने का लिमिटेशन है, लेट्स से फॉर एग्जांपल, आपने इसका जवाब दे दिया, उसने वो 4 महीने अपनी फाइल में घूमता रहा, उसके बाद काम खत्म हो गया, शो कॉज नोटिस पीरियड इज ओवर. Because this is a mandate through an amendment in law, they have said so, and many high courts have also said. So DRC 01 is just nothing, but you still have to file reply. Do not ignore DRC 01. So we will not go through high court judgments. आपको judgment अब आगे है, आगे चलो बेटा. Rahul, there is no time for giving replies, please. You can send email to my mom Kemkaji, we will reply. Now, this is a judgment of latest of Jharkhand High Court. Achhi judgment hai, that's why I have given to you. Nikas Service Private Limited, ASEAN issued section 74, he was challenged. On the ground, it was vague and does not disclose the offense and contravenes as it is a mere mechanical reproduction of previous section 4 without striking it relevant portion. Contended by petitioner that Honorable High Court noted the impugned notice and so and so, thus so and so. उन्होंने बोला there have to be clearly asserted in the notice so that so and so. आगे चलो. Let's see the order. Now, if you read this para 17, this is the crux of DRC 01, read with rule for 142 and 61 and 73-74. As observed herein above, the impugned notice completely lacks of fulfilling the ingredients of a proper show cause notice. तो जब आप अपील ड्राफ्ट करते हैं या कोई जवाब ड्राफ्ट करते हैं, आपको ध्यान से पढ़ना है पहले 73-74. अगर 10 नोटिस आते हैं, आप 10 बार ही पढ़ो उनको. There is no lawyer in the world who says I know everything. It's not possible. Law is an evolving concept. अभी सुप्रीम कोर्ट ने कल कहा सबके खिलाफ एफआईआर लॉन्च कर दो, कंप्लेंट हो जाना हो. ये आज तक लॉ नहीं था. तो लॉ इवॉल्व्स विद द टाइम. आपके पास 10 नोटिस हैं, हर बारी सेक्शन को पढ़ो, इसके बाद कोई और जजमेंट है उसको पढ़ो बिफोर यू ड्राफ्ट योर रिप्लाई. दैट्स व्हाई यू मस्ट टेक लॉट ऑफ मनी फ्रॉम द क्लाइंट. नथिंग इज फ्री. बट वंस यू डू ए शॉर्टी जॉब, 50 पेज का जवाब फाइल कर दिया जिसकी कोई रेलेवेंस नहीं, आई विल टेयर इट ऑफ. बेकार है, कबाड़ है. यू हैव टू बी कंप्लीटली ऑन द फैक्ट्स एंड लॉ कि हाउ दिस नोटिस इज नॉट रेलेवेंट. A summary of show cause notice so and so cannot substitute the requirement of proper notice. This court, however, is not inclined to draw an issue whether required. उन्होंने इसको वापस भेज दिया जो भी किया. अब यहाँ एक बहुत बड़ा इशू है. DRC the one was issued 6 months before, as against the limit of 3 months. Let us say, for example, हाई कोर्ट ने 6 महीने लगा दिए उसको डिस्पोज ऑफ करने में. अब कैन दे इशू another notice in 74 when it has become time barred? Well, that's a big question we have to debate, and therefore you must take a point. This is time barred. High Court has no power to extend the limitation of section 74. Even if they have power, we should challenge the Supreme Court. Only in writ they have certain powers which they cannot extend the limitation given by a statute. That's why the delay in filing appeal more than 1 month cannot be condoned even by Supreme Court. The Supreme Court की बहुत सारी judgments हैं इसके ऊपर. This delay we cannot condone. There is no power with us. So Supreme Court or High Court cannot write a statute. They cannot legislate. They can interpret a law. अब इसमें उन्होंने क्या लिखा? ये बहुत जरूरी चीज पढ़ना है. तो बहुत अच्छा है. This court find that upon perusal of Annexure 2, which is the statutory form DRC 01 issued to petitioner, although it has been mentioned that there is a mismatch between GST 3B and 2A, DRC 01 में लिखा है ये, not show cause notice. But that is not sufficient as a foundational allegation for issuance of notice under Section 4. Is totally missing, and the notice continues to be vague. Since we are the considered view that improved show cause notice as contained so and so does not fulfill the ingredients of a proper show cause notice, that is 61 के बेस पे उसने कोई इंक्वायरी की, उसमें कुछ भी बकवास लिख दिया, आप चोर हो, चक्के हो, जो मर्जी लिखा प्रॉपर ऑफिसर ने, जो उसकी विजडम में लगता है, उसने डीआरसी उसकी समरी शो cause notice के दे दी. कहते हैं that is not the foundation. You have to follow the show cause notice requirement. जो भी आपको केस बनाना है सेक्शन 73, 74 के अंदर, वो आपको शो कॉज नोटिस बनाना. दैट इज व्हाट विल ट्रिगर द लिटिगेशन, नॉट द DRC 01. इट्स मैंडेटरी ओनली फॉर एन ऑप्शन टू गिवन टू द टैक्स पेयर के डिपॉजिट. यार पेनल्टी पेनल्टी छूट जाएगी, तेरी जान छूट देगी, शो कॉज नोटिस इशू नहीं होगा और इसका कोई पर्पज नहीं. नेक्स्ट, अब देखो इसमें क्या लिखा कोर्ट ने. However, since the court has not gone into merits of the challenge, respondents are at liberty to initiate fresh proceedings from the same stage in accordance with law within a period of 4 weeks today. अब हाई कोर्ट ने लिख दिया कि the period taken in the court is excluded. Supposing 2 साल बीत गए, अब हाई कोर्ट ने लिख दिया. That is, Section 14 of Limitation Act says that if you are pursuing a remedy and you fail in that, that period can be excluded. Many courts have held that provision like condonation of delay 3 months, 1 month does not take into its ambit the section of Article 14 or 12. इन दोनों में अगर कोई आप टाइम स्पेंड करते हैं, wrong jurisdiction or fighting case for the same relief, that period can be excluded. This is applicable to both. अब ये लिखा है within 4 weeks. This is a mandate of High Court. 4 महीने में अगर आपको नोटिस नहीं आता, notwithstanding whether it's a directory or mandatory direction, you have to write to the authority, look, it's time barred. Don't issue anything. Let him issue. He will issue. Then we say, ASM में लिखा है कि आपने you have stated that many suppliers have been deregistered वगैरह वगैरह, उसका हमने ग्राउंड लिया है सारा. फिर उसमें केवैट की जजमेंट को हमने लागू किया है. अराइज इंडिया को लिखा है जजमेंट को, इट्स ओनली अ ग्राउंड. In my opinion, these have no relevance in GST law. अगर क्वेस्ट मार्केटिंग रेलेवेंट नहीं थी, इतनी अच्छी जजमेंट थी, और तो ये जजमेंट तो एक पर्टिकुलर पॉइंट पे है. बट एज लॉयर्स वी टेक दिस ग्राउंड्स कि ये दोनों जजमेंट उसके खिलाफ है, इसलिए जो आपका बोलता है कि retrospective cancellation हुआ, it doesn't affect my liability. The fundamental principle running the taxation law is a judgment of State of Maharashtra versus Race Trading Company. These are under central sales tax, where the C forms, the registration certificates. Rajesh Jan have done this case in Jodhpur High Court, a very Jodhpur Tribunal High Court, where a very detailed judgment got passed, where he won, where they say, what are my rights when I file the returns? उस रिटर्न में वो डीलर जिंदा थे, मरे नहीं थे. अब आप रिट्रोस्पेक्टिव कैंसिल करते हैं, तो कैन यू अफेक्ट माय राइट? क्योंकि श्रेष्ठ ट्रेडिंग में ये पावर नहीं थी जो यहां पर है. तो वंस द लॉ हैज बीन एम्पावर्ड टू कैंसिल सर्टिफिकेट्स रिट्रोस्पेक्टिवली फ्रॉम द डेट ऑफ रजिस्ट्रेशन, दैट इज फ्रॉम 1st July 2017, these suppliers were deemed to be not registered, and if they were not registered, then you do not satisfy 16(1). You are not buying from a registered supplier, and he had no power to issue tax invoices. So this is what the story which is coming up in Supreme Court, where they are, in all cases, they are passed till today. They have strictly followed the law. Be it Bharti Airtel, be it inverted duty structure, be it refund cases, be it bail cases, they have strictly followed the law. Therefore, let's see when it goes to case. But we have taken this ground. Next, please. I have quoted this case of State of Maharashtra Street Trading Company. आगे चलो, इसको ले लो, आगे ले लो. We will. Interest, अगर इंटरेस्ट लगता है तो आपको इंटरेस्ट को भी कंटेस्ट करना है. Though interest is consequential to levy of tax. If tax goes, interest also goes. But in many cases, we know interest was quashed, not the tax. in VAT laws or sales tax law, JK synthetics. So interest जब लगाया जाता है 51 में, आपको उसको भी ध्यान से पढ़ना है. क्या कहीं आप उसमें बाहर तो नहीं हो सकते, उससे बाहर हो सकते हैं, तो JK ग्राउंड के सेक्शन 50 is not applicable. Say for example, you deposit tax through electronic cash ledger. आपके पास इलेक्ट्रॉनिक कैश ledger में टैक्स था, आपने रिटर्न 1 महीने के बाद भरी. Is it a compliance of law? Recent courts have held no. You are liable to pay interest. You paid through cash. पैसा गवर्नमेंट के पास पड़ा था. They were enjoying. But the court said, since this is not the return filed as per prescribed under law, you have to pay interest on the gross amount. Net amount का notification मुझे पता हुआ या नहीं हुआ, I am not aware of it. But I don't do all this. अब झारखंड हाई कोर्ट ने एक और जजमेंट थी, ये भी अच्छी जजमेंट है, वो भी सेक्शन 70-74 में ही है. वहां भी उन्होंने बोला कि ये नोटिस ठीक नहीं है, आप हम वापस करते हैं. नेक्स्ट प्लीज, नेक्स्ट पेज 7. सेक्शन इसमें महादेव की जजमेंट में उन्होंने एक इंटरेस्ट इशू को लिया सेक्शन 50 के. ये अच्छा इशू है, दैट्स व्हाई आई एम गोइंग टू टेकिंग योर टाइम. Whether interest liability section 50 can be determined without initiating any adjudication process, either section 73 or 74. Remember, demand and recovery chapters contains only 2 key sections, 73, 74. 75 till 80 are parts of machinery provision, how to recover. 76 on a different footing, but main sections are 73, 74. Whether recovery proceeding under 79 can be initiated for recovery of interest, 79. Jharkhand High Court ने क्या कहा? This is not a very solid judgment, but very relevant. अगले चलना है, इसको रितिका लेना आगे. हाई कोर्ट कहता है हमारे सामने 2 क्वेश्चन है, 73-74 के नोटिस में विदाउट एडजुडिकेशन कैन यू लेवी इंटरेस्ट, और अगर 79 में रिकवरी प्रोसीडिंग होती है, मैं पट्टा पैसा नहीं देता, कैन यू रिकवर इंटरेस्ट अंडर सेक्शन 79. नेक्स्ट, थोड़ा आगे चलेंगे पेज 7 में. हाँ बस. The Honorable High Court had so and so. A bare reading of, now this is how to read law for the first timers. आपको हर चीज को लॉ को पढ़ना है, ध्यान से पढ़ना है. That a bare reading of 73(1) of the Act reveals that where it appears to the proper officer that any tax has not been paid or short paid, the proper officer shall serve a notice on person chargeable with tax, which has not been so paid or which has been short paid, requiring him to show cause as to why he should not pay the amount specified notice along with interest payable, so and so, and a penalty leviable. Thus, in terms of section 73(1), if tax has not been paid or has been short paid, 2 circumstances आपको नोटिस इशू कर सकता है. Has not been paid or short paid, a notice required to be served assessing, not only requiring to so and so, but also specifying. The Honorable High Court in para 19, आगे चलेंगे रितिका. As regard the issue whether in respect of cases whether tax has been paid or some after pay would be covered under inspection, tax not being or short paid, has relied. थोड़ा चलेंगे आगे रितिका इनको. चलो ठीक है, चलो. Has relied their judgment on so and so, wherein the court observed that in cases where the tax was not paid for any reason other than fraud, the tax was not paid by the petitioner company in government account within the due date, and accordingly it's a case of tax not being paid with the prior period or when due, the minimum requirement that principle naturally must be followed. तो 73-74 के जो 2 रीजन है इंटरेस्ट के लिए, शॉर्ट पेड और नॉट पेड, उसके आगे को तीसरा ग्राउंड है तो शो का नोटिस देना, बट इट हैज टू बी एकिन टू दोस ग्राउंड्स. नेक्स्ट ग्राउंड हमने लिया है, द पिटिशनर हैज नॉट एंगेज्ड इन एनी केस ऑफ टैक्स इवेजन. ये अपने क्लाइंट को पैम्पर करना चाहिए कि हमने कोई ऐसे टैक्स इवेजन नहीं किया है, हमने नॉर्मल कोर्स में बिजनेस किया है, और मेरा जो आईटी से क्लेम है वो सेक्शन 16 और 49 की रिक्वायरमेंट स्ट्रिक्टली सेटिस्फाई करता है. फॉर एग्जांपल, सप्लायर की रिटर्न है, फाइल्ड है, सब कुछ फाइल्ड है, और वो कहता है बोगस डीलर है, but he has to still bring me my case in 73-74. बोगस डीलर तो बात नहीं बनेगी कहने से. मेरे पास सेक्शन 16 रिक्वायरमेंट सेटिस्फाइड है, 49 की सेटिस्फाइड है, ये 2 ही सेक्शन रेलेवेंट है. अब उसके हिसाब से मेरा आईटीसी बनता है, मैंने ले लिया. अब कहते नहीं वो तो चोर था, उसके खिलाफ तो हमारी बड़ी रिपोर्ट है, उसके खिलाफ तुम्हारे पास क्या है, दिस नन ऑफ आवर बिजनेस. बट इफ ही रेजेस दिस इशू and brings you within the ambit of section 74, any of those 3 clauses, then you have a case at hand to contest. Subsection 9, so and so, if an objection response is filed to show cause notice, then after consideration officer will determine the amount of tax. आपको 73, 74, 9 में reply जरूर file करना है. Let him determine tax. Unless you want to pay with interest and penalty or no penalty, with DRC 01 itself, or after notice is 73 without penalty, or after 74 with penalty of 15%, you pay, finish it off. But if you don't want to pay, you have to file a detailed reply. Reply means you have to hit the foundational basis of this show cause notice. Don't write हम बड़े honest हैं, हमारा 50 साल से धंधा हो रहा है, हम रिलायंस से डील करते हैं, हम हमारे मिस्टर वर्मा वकील हैं, हमारे मनमोहन खेमका जी हमारे, इसे नो कस्टमाइज इन लॉ. आपको उस शो का जवाब देना है, उसको उसके लाना है कि ये शो का नोटिस गलत था, इसलिए ये गलत चीज है. Then next, the proper officer has relied upon many document statements of third parties. Here, this is the main case in 7074 in today's GST litigation. जिस स्टेटमेंट की वो आपको बोलता है उसकी सारी कॉपीज आपको मिलनी है, जो भी उसने लिखा है, जो एविडेंस उसने रिलाई की है, उसका जवाब आपको देना है. उसका मांगना है कि डॉक्यूमेंट नहीं मिले, हम डॉक्यूमेंट दो. उसके लिए आपको एक एप्लीकेशन फाइल करनी है कि भाई ये आपने जो एविडेंस है हमारे को दी नहीं, आपने दीजिए. और अगर वो आपको नहीं देता है, फिर जब अपील में जाते हैं वहां भी आपको ग्राउंड लेना है कि we should be allowed to prove additional evidence which is in the custody of proper officer. He did not give us, we took steps. Let him call. तो अगर किसी पार्टीज को रिलाई करता है तो उसको क्रॉस एग्जामिनेशन के लिए आपका राइट है. सीजिंग ऑफिसर को एग्जामिन करने का आपका राइट है, उसने कैसे किया था. और जब वो सर सीधर कैसे में उसको बाद में करते हैं, चलो इसको भी नहीं करते, आगे चलो. Verification is a must in appeal. Next. Now, there are 2 appeals of registration. एक तो नॉन फाइलिंग ऑफ रिटर्न्स है, आपने 6 महीने में नहीं की, सेक्शन 30 की एप्लीकेशन आपकी नहीं मानेंगी, रिवोक कर दी गई, आपको अपील फाइल करनी. 4 चीजें आपको इसमें लगानी है कि कितनी आपकी टैक्स लायबिलिटी है, कितने परचेज सेल वोचर है, अलॉन्ग विद सीए सर्टिफिकेट. सीए सर्टिफिकेट इज अ मस्ट. आपकी स्टेटमेंट की कोई वैल्यू नहीं, आपने रिटर्न नहीं भरी तब आपकी वैल्यू नहीं थी, अब आपकी क्या वैल्यू. सी सर्टिफिकेट लगाइए कि ये इसके टर्नओवर है, बैंक स्टेटमेंट लगाइए कि हमारे बैंक में इतने पैसे आए हैं, और एफिडेविट दीजिए हमने और कुछ नहीं किया, आई एम विलिंग टू डिपॉजिट टैक्स, माय आरसी बी रिस्टोर्ड. जब आपका आरसी कैंसिल, आप टैक्स एनवाइस इशू नहीं कर सकते, ना आपको कोई कर सकता है. Therefore, there is no way out except to file return for 6 months. अगर सेक्शन 30 की आपकी एप्लीकेशन आप टाइम पे फाइल नहीं करते, यहां वो नहीं मानी जाती, तो देन यू हैव ए प्रॉब्लम. आजकल तो ऑटोमेटिक 6 महीने टर्न बोलो तो आपकी ऑटोमेटिक हो जाती है. एम आई राइट मनमोहन?
नहीं सर, अभी ऑटोमेटिक तो नहीं हो रही है सब केसेस में.
अच्छा, तो एनीवे जो भी इशू है, अगर अपील करनी है तो आपको ये चीजें साथ लगानी है. अगला लो भाई, नेक्स्ट लो. ये ग्राउंड ऑफ अपील है. आई टुक टाइम टू प्रिपेयर इट कि जो सीबीएसई का नोटिफिकेशन कॉपी लगाई है कि उन्होंने एक बड़ा एक बेनिफिशियल इंटरप्रिटेशन ली है, और मेरे पास सफिशिएंट रीजन थे. क्या रीजन थे आपने रिटर्न को नहीं फाइल की? रीजन आपको देने. अपील में सेक्शन 30 में तो रिटर्न भरी, बात खत्म. आप अपील में पहुंच गए जहां आपको रीजन देने होंगे, आपने क्यों नहीं. इलनेस हो सकती है, बीमारी हो सकती है, घर में डेथ हो सकती है, इनकैपेसिटी हो सकती है, वो दुकान बंद होगी, पार्टनर के झगड़े हो गए, जो भी आपके डिस्प्यूट्स हैं वो आपको एविडेंस के साथ लगाने का हमारा ये इशू था. अब बोलो जी मैंने पैसे इकट्ठे कर लिए, मैं टैक्स जमा कराना चाहता हूं, मेरा आरसी रिस्टोर किया जाए. नेक्स्ट. I'm not devoting time because it's very simple. I'm sure all of you know it. Then it is 29(2) cancellation. कि उन डीलर के सर्टिफिकेट कैंसिल कर दिए गए जो चोर थे, उन रेट्रोस्पेक्टिव कैंसिल कर दिए और आपका आरसी कैंसिल कर दिए. इसका we have discussed most of this. आगे चलाना है बेटे का इसको. We have discussed most of this. अपील के फंडामेंटल है इसमें. अब इसमें आपको क्या देखना होता है कि 29(2) में जो इसको पावर है, सब क्लॉज सी या जो भी है, जो रेट्रोस्पेक्टिव पावर है, क्या इसने उस सेक्शन में ऑर्डर पास किया है? उस पावर को एक्सरसाइज करने के लिए कुछ ग्राउंड्स हैं. उन ग्राउंड में आपको देखना है हैज ही एक्सरसाइज दैट पावर एज पर लॉ, देन यू हैव टू टेक ए ग्राउंड उसने किया या नहीं किया, आगे चलना। बाकी वही है, ये हमारे पास किताबें हैं, परचेज रिस्पेक्टेड हैं। देन it's another legal question still to be tested, but I have taken this one of the cases in Maharashtra that once a registration is granted, the same could be cancelled only in terms of condition because of 29(2), and allegedly being a bogus firm is not a ground enumerated section 29(2). जो 29(2) में ग्राउंड है उसी पे आपका आरसी कैंसिल हो सकता है। Being a bogus dealer, dealing with bogus dealer is not a ground for cancelling RC. आप उसको प्रोसिक्यूशन करो, अरेस्ट कर लो, पेनल्टी लगाओ, टैक्स निकालो, जो मर्जी करो। But now on a similar line, there was a case of Maruti Wire in Supreme Court, where a dealer did not file the returns at all taxable turnover. जब वो पकड़ा गया तो उसको बोला भी टैक्स दे और इंटरेस्ट दे, तो कुछ वकील ने बोला किस बात का इंटरेस्ट भाई, इंटरेस्ट किस बात का, टैक्स तो तुम्हारा बनता ले लो। कहते कमाल है यार, तुमने 4 साल टैक्स दिया, इंटरेस्ट दो। तो सुप्रीम कोर्ट ने बोला इंटरेस्ट वाज लेविएबल ओनली इफ टैक्स वाज नॉट एज पेड एज पर रिटर्न्स। If returns were not filed, where is the question of interest? आप उसको जेल में डाल दो, पेनल्टी लगाओ, जो मर्जी करो, इंटरेस्ट की वैल्यू नहीं बनती। इसलिए अगर 29(2) में ये ग्राउंड नहीं है, और ये इलाहाबाद हाई कोर्ट की 3 जजमेंट है इसके ऊपर जो मैं आपको दे रहा हूं, मैं बोला ये ग्राउंड नहीं है। नेक्स्ट, आई एम नॉट रीडिंग जजमेंट्स, आई एम श्योर दे आर वेरी सिंपल लैंग्वेज रिटन। अब ये जस्ट सी पैरा 5, applicant separately moving the application before your good self to call the entire evidence statement that the officer has used against the appellant, appeal FSR authority के लिए, and the further requesting to call the persons whose statements are recorded. I have a right to cross-examine. How can you cancel my RC based on accounts of third parties? That is not done. Therefore, I have given you many judgments, but don't quote all. आगे चलना है रितिका। ये सारी जजमेंट्स हैं, उसी में 6-7 जजमेंट्स हैं, उसी चीज के ऊपर है ये। चलो आगे, भी मुझे पढ़ने की जरूरत नहीं है इसमें, जजमेंट को क्या पढ़ना। अब प्रेयर आपको चलो प्रेयर। In view of the above, it is prayed that the improved order of proper officer date may be quashed and registration certificate of appellant be restored to the original number. अब कभी-कभी क्या होता है, हमने केस में ट्राई किया, हमारी पहले एडमिट हुई है, जिनको हमने सेल की, जिनको इनपुट टैक्स क्रेडिट मिलना है और हमारा कैंसिलेशन बैक हुआ, हमने उनसे भी अपील डलवा दी। अब उनकी वहां प्रॉब्लम है डेट ऑफ कम्युनिकेशन की। अब उनको तो पोर्टल खुलता नहीं, वो तो मेरा पोर्टल नहीं खोल सकते ना। तो हमने उनका एफिडेविट दिलवाया कि ये हमें पता चला, हमने इससे बात किया, हमने इस डेट पर चला हमारी अपील लिमिटेशन में, अपील हैज बीन एडमिटेड, डिसीजन क्या होगा मैं पता नहीं। तो अगर कोई बड़े स्टेक हो तो एज ए लॉयर यू मस्ट फॉर्म ए स्ट्रेटजी, कैन यू ब्रिंग इन कोलेटरल पार्टीज हु वर नॉट ए पार्टी टू योर प्रोसीडिंग टू अपील इन योर केस बीइंग एग्रीड पार्टी। तो इस वाले कैंसिलेशन केस में जहां बड़े हाई स्टेक हैं और आपको पता आपका क्लाइंट बोगस है, चोर है, एक नंबर का, जो वट एवर, एंड वेयर यू थिंक कि जेन्युइन पीपल में सफर, तो एक जस्ट टू पुट सम प्रेशर कि हमारे राइट आप अफेक्ट नहीं कर सकते आप उसमें, हालांकि नॉट दैट देयर विल बी मच बेनिफिट, बट it's better if they file appeal and you get more work to file appeal. Next, please. This is a party, this is an application calling the parties for cross examination. हर अपील के साथ आपको एप्लीकेशन ये मूव करने, इस पे टिकट लगती है नहीं लगता मुझे पता नहीं, आगे चलना। यार स्टॉप हियर। That the appellant, थोड़ा ऊपर करो रितिका, that the appellant has filed an appeal before your good self, whereby the appellant, feeling aggrieved with the order of proper officer dated so and so, cancelling so and so, the process has relied upon the records of party, सारी पार्टी आपको मेंशन करनी है, किनका रिकॉर्ड से मेंशन किया नेक्स्ट लगाकर, on certain document mention, दोनों चीज आपको पार्टी डॉक्यूमेंट्स, the document statements parties have been used against the appellant, क्योंकि शोकाज नोटिस में या उसके ऑर्डर में लिखा है कि आपने लोगों ने डील किया जो चोर थे, मैं आपको टैक्स लगाऊंगा। Behind the back, and no explanation was sought or an explanation has been rejected without assigning any reason, or the request for appellant was rejected by officer for cross-examining so and so. That the appellant right to cross-examine the parties examine so and so. ये application आपको move करनी है, इस application को उस पर decision देना है। So this application when it disposes of, he will pass an order, not a decision. that this appeal is in the continuation of a proceedings of restoration of your RC. So if he denies this, you can further appeal or go to High Court against this. But if you think this is a must, ये झूठ बोल रहा है, ये पार्टियां मर चुकी हैं, then you have a strong case. Yes, this order was passed without jurisdiction. Next, please. Now, this is appeal in search and seizure cases. Again, basically the same grounds, लेकिन उस कुछ चीज में तीन चीजें जरूरी होती हैं इसमें सर्च एंड सीजर में. पहले 67 में वो क्या कर सकता है वो देखना आप. फिर 67 में क्या उनका jurisdiction बनता है. Jurisdiction है an officer not below the rank of joint officer, duly authorized by and so, वो उसकी आपको पावर देखने क्या उसने पावर एक्सेस की. Even if you did not ask him at the time of search, since it's a question of jurisdiction, you can always ask in a first appeal. तो पेपर में दिखाई नहीं कि हमने मांगे थे, इन्होंने दिखाई नहीं हमारे. Then whether the timelines were complied with. एक साल जो भी अभी अब तो काफी सेक्शन बढ़ गया इसका, लेकिन जो इसके टाइमलाइन था उसमें हमको कंप्लाई की, या आपको सर्टिफाइड कॉपी दी या नहीं दी, उसकी भी काफी आपको मांगनी अपील करने से पहले, तो उसका आपको जवाब चाहिए. उन्हीं के बेस पे यू विल आस्क फॉर राइट ऑफ एग्जामिनिंग थर्ड पार्टीज. और 107 में जो डॉक्यूमेंट सीज किए जाते हैं, डॉक्यूमेंट आपके हो सकते हैं, किसी और पार्टी के हो सकते हैं अपने यहाँ. They can use both these documents against you, and you have to have a right to take copies of both the documents before you file a reply. If they don't give you, if they refuse to give you, you have a right to go to High Court or file a further appeal in tribunal, no tribunal. But बिना उन copies के जो आपके पास नहीं है, आपको जवाब दाखिल नहीं करना चाहिए. You should take them on. Next. चलना बेटा आगे. अब इसमें भी सर्च एंड सीजर में भी अपील है, तो 10% आपको जमा करना है. कोई रेक्टिफिकेशन हो सकती है एज पर यू, देन प्लीज फॉलो द रेक्टिफिकेशन रूट एंड रिड्यूस द टैक्स लायबिलिटी. दैट्स एक्सट्रीमली इंपॉर्टेंट, सो दैट द 10% यू डिपॉजिट. अब ये फैक्टोरियल मैट्रिक्स से हमने एक हाइपोथेटिकल केस बनाया है. फैक्टोरियल में एक पैरा पढ़ लेते हैं. Pursuant to such conductive officer department at the business premises so and so, certain documents were seized along with the other documents on 67 so and so. The visiting officer recorded the statement of one employee, Mr. X. कोई statement जो आप देते हैं under question, this can be retracted. File application next day before the same team. कि you took the statement under question, I hereby retract this statement. कानून में है या नहीं, इसे नेचुरल लॉ. क्या किसी का बंदूक रख के आप स्टेटमेंट लेते हो तो नहीं. जैसे अभी आज ही मैं हाईकोर्ट जजमेंट पढ़ रहा था अभी आज दोपहर कोई, कि जो पैसा आप सर्च सीजर में जमा कराते हो, इट कैन नेवर बी वॉलंटरी. हाईकोर्ट सेज डिपॉजिट रिटर्न विद इंटरेस्ट. दिल्ली हाईकोर्ट जजमेंट है. आज एक और आई है मेरे ख्याल तेलंगाना की, आई डोंट नो व्हिच कोर्ट. कहते हैं सर्च सीजर में जो पैसे जमा कराते हो वो वॉलंटरी हो ही नहीं सकता. बंदूक पर आप उस पैसे को वापस करो. तो अगर कोई स्टेटमेंट जिसकी रिकॉर्ड की जाती है, अगर वो ऑथराइज नहीं था, उससे जबरदस्ती साइन कराया गए, उसकी हैंडराइटिंग उसकी नहीं थी, तो आपको एक लेटर देनी अगले दिन कि दिस पर्सन वाज नॉट ऑथराइज्ड, ही डजंट डील विद दिस काइंड ऑफ बिजनेसेस, ही डजंट नो एनीथिंग अबाउट दिस, एंड यू फोर्स्ड हिम टू साइन दिस स्टेटमेंट एज पर ही हैज टोल्ड अस. देयरफॉर नाउ ही इज रिट्रैक्टिंग स्टेटमेंट एज पर लेटर एनक्लोज्ड, एंड अकॉर्डिंगली वी रिट्रैक्ट दिस स्टेटमेंट. लेट देम डू व्हाटएवर दे हैव टू डू. ठीक है. ये इसमें हमने वही लिया, एचएसएन क्लासिफाइड झगड़े हैं, तो अपने GST में 3P के झगड़े हमने लिए हैं, और सप्लायर्स हु आर नॉट फाउंड फंक्शनल, ये सारे जो हमने ऊपर सारा किया है उसी के बेस पे सर्च एंड सीजर की अपील है. जो पॉइंट को ले सकते हैं उस सब के जवाब आपको इसमें हैं अवेलेबल. आगे चलाना इसको. देन यू कम टू ग्राउंड्स ऑफ अपील. ग्राउंड ऑफ अपील में कोई आपका दिन का इश्यू है, कोई नोटिफिकेशन का इश्यू है, कोई इंस्ट्रक्शन का इश्यू है, जो आपके पास हैं वो सारे के सारे लेने. और अगर 67(2) में कोई इसका जुरिडिक्शन नहीं था, तो द होल सर्च इज आर्बिट्रेरी एंड इलीगल. दैट डजंट मीन मटेरियल कैन नॉट बी यूज्ड अगेंस्ट यू. वो एक अलग इशू है. इनकम टैक्स की लेटेस्ट जजमेंट का GST से कोई लेना देना नहीं. इनकम टैक्स 53A 220 हुआ डिफरेंट प्रोविजन, वो प्रोविजन GST में नहीं है. नेक्स्ट प्लीज. रितिका करना बेटा आगे। ये सारे जो अंडरलाइन वर्ड्स हैं, दिस वी हैव ऑलरेडी डिस्कस्ड क्रॉस एग्जामिनेशन वगैरह, बट आई हैव हाइलाइटेड देम कि ये ग्राउंड आपको लेने हैं। चलते चलो, बस यहाँ रोक लो, यहाँ रोक लो, पीछे पीछे थोड़ा और पीछे चलो, या थोड़ा और नीचे आओ। इट्स अ गुड जजमेंट। वो कहते हैं सुप्रीम कोर्ट इन सो एंड सो, सुप्रीम कोर्ट हैड एन ओकेजन टू कंसीडर द एप्लीकेबिलिटी ऑफ प्रिंसिपल ऑफ नेचुरल इन ए रीसेंट केस सो एंड सो, सुप्रीम कोर्ट इन चेयरमैन सो एंड सो, नेचुरल जस्टिस is no unruly horse, no lurking landmine, nor a judicial cure of all. If fairness is shown by a decision maker to a man proceeded against the form, features, and fundamentals of such essential procedural propriety being conditional by the facts, circumstances such situation, no breach natural can be complied. Unnatural expansion of natural justice, वो कहते हैं ये सब कुछ आपको बता दिया गया था और अगर आपने नोटिस नहीं दिया, is it a violation of natural justice? But we have to attack on a different ground. Okay, this notice was prescribed like Shoka's notice. DRC 01 is a summary of assessment of Shoka's notice. But court says this is not a Shoka's notice. So this judgment has been relied in one of the cases where appeal was dismissed. That's why I mentioned here that this judgment इतनी relevance इसमें नहीं है क्योंकि हमारा जो legal provision है वो इस judgment से अलग है. Next आगे चलना. थोड़ा पीछे. It's another good judgment. हाँ, बस यहाँ छोड़ दो. Regarding reliance of evidence statement third parties and their presence and closing before the movement part, it is submitted that their statements cannot be considered on the face of it without testing them for truthfulness. It is more so in case where the statements were only evidence available with the department in support of their case. Facts that the statements were voluntary and allegations are false or true must be cross-examined at the earliest point of time as the averments made in the statement found to be insufficient. This is what Delhi High Court said in a case of custom. आगे चलो. ये जो काफी सारी रिपोर्ट्स लिखते हैं, तेरा पंचनामा हो गया, तेरी इन्वेस्टिगेशन रिपोर्ट है, एफआईआर है, ये सारा है, आपको सारे डॉक्यूमेंट मांगने का हक है. In search and seizure cases, appeals, the biggest strategy is if you can delay the proceedings by time to prepare yourself. And these are the statutory techniques which we lawyers should use to buy more time for the authority. अगर लॉ में 30 दिन लिखा है और वो 3 महीने को देने में लगाता है तो मुझे 30 दिन अभी और मिलने हैं, वो एप्लीकेशन में लिखना है आपको. This period be granted and my time be extended for 30 days when you supply this to us. So उसकी भी हमने एप्लीकेशन बना के दी आपको. उसके बाद आपको सर्च सीजर में एक रिकॉन्सिलेशन जरूर देना. कई सीए मेरे को बोलते हैं 99C का क्या मतलब है, इसका कोई मतलब नहीं, जीरो डॉक्यूमेंट. That's only a statement you reconcile and give yourself. You are not an authority who detects frauds. You are not an authority who detects willful misstatement. You audit a party or you fill these forms based on information given to you. So therefore, ये जो भी रिकॉन्सिलिएशन स्टेटमेंट है अगर आपको साइन करनी है तो बहुत ध्यान से करनी है, गलत है तो गलत. नेक्स्ट यू कैन रीड पैरा 6, मुझे इसमें कितना पढ़ने की जरूरत नहीं है. नेक्स्ट प्लीज. यस, ये वो सर्टिफिकेट कैंसिलेशन वाला आगे चलते चलो कर चुके हैं हम. ये सेक्शन 73(4) का इनपुट टेस्ट क्रेडिट मैंने गलत नहीं लिया, सब ठीक लिया है. ये एलिगेशन बेसलेस है, हमने बोल दिया इसको. ये जरूरी होता है इनपुट टेस्ट क्रेडिट में. आपको मैंने तो एक पैरा लिखा है, आप पूरा एलोबरेट कर सकते हैं कि भी मैंने रूल 36 को वायोलेट नहीं किया, 37 वायोलेट नहीं किया, रूल 42 मेरे को फेवर करता है, सेक्शन 16 की मैंने सारी कंडीशन सेटिस्फाई की हैं, जब 180 दिन है ये वो, और 16(2) सेटिस्फाइड है, 16(4) सेटिस्फाइड है. अब उसने मेरे सप्लायर नहीं किया तो उससे मैं क्या करूं? But if your supplier has not filed returns, input tax credit cannot be given to you. It may be amount to a double taxation, but ITC being a concession given by a statute, it can be subject to certain conditions. ये fraud के ऊपर लिखा है ground. Next, I think after this we will stop. रुको 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 रुको. ये भी जरूर लिखना है कि आपकी जो ट्रांजैक्शंस हैं, ये भी कभी कोर्ट कहते हैं हमने कहाँ लिखा है कि आपने बोनाफाइड परचेज किए. Supposing you are a transport company. You are buying dry fruit and claiming an input tax credit. You have to give reasons. How was it a bona fide purchase for input tax credit? Diwali gift, तो गिफ्ट आरटी से मिलता नहीं. सेल्स प्रमोशन में नॉट अलाउड. तो कुछ चीजें ऐसी हैं जब आप अपील तैयार करते हैं आपको पता चलेगा कि क्या इस बंदे ने ठीक इनपुट टैक्स क्रेडिट लिया है. दैट इज सेक्शन 16, सेक्शन 17(5) ब्लॉक्ड आईटीसी नोटिफिकेशंस आपको देखने हैं. और सेक्शन 17(5) की जो हर एंट्री में एक्सेप्शंस हैं, अगर उनका केस एक्सेप्शंस में आता है वो भी आपको देखना है. फॉर एग्जांपल वो कहता है जी आपको ट्रकों का आईटीसी ले लिया, आपने कारों में आईटीसी ले लिया. हाउ कैन यू टेक इट कार पे आईटीसी? अब हो सकता है वो आपकी रिटर्न में जो आपने राइट टू यूज पे टैक्स इकट्ठा किया था, जो कारें आपने किराए पे दी थी, आपने रिटर्न में नहीं दिखाया. दैट्स योर क्लेम व्हिच हैज रिमेन्ड व्हिच इज नॉट इन रिटर्न्स बट दे आर दैट्स इन देयर बुक्स. उसको असेसमेंट में फाइल करो जी ये ठीक लिया मैंने, ये मैंने टर्नओवर दिखाई नहीं, मैंने टैक्स जमा करा रखा है या टैक्स चार्ज किया जमा नहीं कराया. उस पॉइंट को आप आगे लेके चलेंगे तो परहैप्स यू विल विन. उस टाइम तो नहीं मिलेगा आपको, लेकिन ये सारी चीजें एज प्रोफेशनल आपको देखना है कि आईटीसी में कहां गड़बड़ हुई. आप करें कोई आपका और आदमी करे. नेक्स्ट
सर, मेरे ख्याल से यहाँ पे कंक्लूड करें.
कंक्लूडिंग नेक्स्ट.
और कुछ क्वेरीज है मेंबर्स की, वो ले लें अगर पॉसिबल हो तो.
Wait. Now, friends, we finish this whole presentation here, and next session, whenever we have, we will take up other than the three things remain. There's a 73, 74 notices how to reply, and the 3 cases of refund rejection appeals. You can read them. I'm available on email. Write to Manmohan Khemka or Anitika Khanna. इनको लिखिए जो आपके queries हैं. But all these are being sent to you on your recorded email today evening in a PDF file. Thank you so much. Thank you.
Thank you very much, Verma ji. We have Rakesh ji also with us. Before we, yes. So a very thorough session from Sushil Verma ji on appeals and its drafting art and science. I will request although we have many queries, but seeing the time constraint, first I will request Rakesh ji to please give his valuable inputs and gist to the members. What additional things one should keep in mind while drafting appeals? Rakesh ji, please.
Thank you, Manmohan ji. All the distinguished guests on the panel and all the friends. इतना thorough session के बाद I don't think anything left to be added. Am I audible?
Yeah, you are audible, sir.
So I don't think much to be added because everything has been covered by Verma ji. What can I do that I can summarize in 5 minutes so that because it was so thorough that might be that is somewhere in the procedure some problem is there. That is why some questions are there. But otherwise, legally, it is a very thorough, very detailed deliberation, and it has covered all the aspects. What I am doing is basically summarizing. The first part, that we all are aware that appeal is not a fundamental right, it is a statutory right. Since the statute has given us the right to appeal, that is why we are filing. If the statute takes away section 107, then we don't have any right. Similarly, as Verma ji told that we have to read section 107 right with 121. 107 says who can and when can be appeal be filed, and 121 that when appeal cannot be filed. So that any decision or order passed by the adjudicating authority, which has been defined under section 2 subsection 14, then if I am aggrieved by such decision or order, I can file the appeal. So first of all, that decision must be passed by the adjudicating authority. If the person is not the adjudicating authority, is simply other person. So we have to go into the definition of section 214, that what is the adjudicating authority? If you go to section 214, as Verma ji has stated in his slide, that adjudicating authority has also been defined that any authority making the decision or order under this act. So there is hardly any difference between the meaning of the adjudicating authority and the term used under section 107. But still, today itself, we were discussing, Verma ji and I was discussing one of the particular case when appeal can be or cannot be filed. Let us take the case of section 61. 61 is the scrutiny of the return. When the assessing officer finds that there is discrepancy in the returns with the information furnished, then he can inform. Here, first of all, he will inform that so and so discrepancies are there, that ASMT 10 is issued. So the first question is, can the ASMT 10 itself is subject to appeal? उसने कहा जी ये discrepancy ASMT 10 आ गया, क्या मैं उसके against appeal file कर सकता हूँ? No, answer is because here he is not adjudicating. Here he is simply informing that this is the information which requires your clarification whether this I am correct or not. So appeal cannot be filed. Now after ASMT, what we do? We will submit our reply. That reply will be through ASMT 11. As Verma ji has told that if the law has specified certain procedure, then we have to follow that procedure only. We cannot say कि नहीं जी हम से online ही file करेंगे, physically file कर देंगे. अगर physically file कर दिया, तो he has the option not to take into consideration. So we will file ASMT 11. अब ASMT 11 से वो satisfied नहीं होता, वो कहता है जी मैं आगे SCL issue करूंगा या मैं आगे audit करवाऊंगा, detailed audit चाहिए 65 में. अब now he has given us the notice for the audit under and issued us ADT 01. Now it is again a decision to get my accounts audited is a decision. So can this decision be subject to appeal? नहीं तो मुझे audit नहीं करवाना. In my view, as we were discussing, perhaps we cannot file the appeal because he is not passing the decision as an adjudicating authority. Though certainly it is a decision, but not as an adjudicating authority. He is simply saying that भाई मुझे जो मैंने आपकी रिटर्न स्क्रूटनाइज करी, इससे सब कुछ आपने दिया, मुझे कुछ समझ में नहीं आ रहा. You require detailed examination through an audit under section 65. तो अगर वो मुझसे ये बोलता है, then हमारा यही व्यू था कि perhaps the assessee cannot file the appeal against the ADT 01.
61 was not an appeal. If on a 61 notice, he issues notice of section 73, 74 and then passes the order.
No sir. No sir. Sir. 61 में नीचे लिखा हुआ है, if he is not satisfied with our reply, yes, then he has got 4 procedures. He can issue 73, 74. He can issue 75, 65. Yeah. He can go for search and seizure, and he can appoint the special audit.
Order pass करेगा, that is available.
These 4 are, he opts for the audit by the department. Supposing he opts for the, he don't go for the, because section 73, 74 is bit specific. अभी तो समझ में नहीं आ रहा करना क्या है मुझे. उसको करने के लिए कहता है जी ऑडिट कर लो, तो आपकी रिटर्न में कुछ बता नहीं रही है, आपने बहुत कुछ कहा, आपके रिप्लाई से कुछ समझ में नहीं आ रहा मुझे. आई रिक्वायर डिटेल्ड एग्जामिनेशन थ्रू एन ऑडिट. इसी तरह से वो अगर मुझे एक तो ये इलस्ट्रेशन हो गया, दूसरा हुआ कि मुझे 73, 74 देता है. अब 73, 74 की ड्यूटी है. 73, 74 में he is duty bound to give me the reason and the amount. If you look at the DRC 01, मैं एक थोड़ा सा क्लैरिफाई करता हूँ यहाँ पर, थोड़ा सा प्रोसीजरली वर्मा जी ने एक दो फॉर्म का नंबर गलत बोल दिया, मैं नंबर ठीक कर रहा हूँ सिर्फ. सबसे पहले वो हमें इशू करेगा 142(2) में DRC 01A. दिस इज कॉल्ड एज प्री शो कॉज नोटिस. यहाँ पे पहले शेल वर्ड था, शेल को उन्होंने मे कर दिया है. उसके बाद हमारी कैलकाटा हाई कोर्ट की जजमेंट आई. एक और जजमेंट आया कि इवन इफ द रूल्स हैज स्टेटेड द वर्ड मे, बट दिस मे शुड बी रेड एज ए शेल. तो वो मुझे देगा. उसके बाद हम आते हैं 142(1) में. वहां पर एक और भी प्रॉब्लम है वर्मा जी, आप इसको नोटिस करना कि वहां पे लिखा है 142 में, the proper officer shall serve a notice under section 52, 73, 74, 76, 122, 125, etc., etc., and shall serve summary of the show cause notice in DRC 01 electronically. Meaning thereby there are two separate things. One is the notice and other is the summary of the show cause notice in DRC 01. And if you go to the title of DRC 01, again they have very categorically stated that this is the summary of the DRC 01. Sorry, summary of the show cause notice. So meaning thereby जो summary है DRC 01 में, ये तो उसे इलेक्ट्रॉनिकली करनी है थ्रू दी पोर्टल, बट व्हाट अबाउट द मेन नोटिस? वो नोटिस का कोई फॉर्मेट, कोई फॉर्म कहीं पे भी लॉ में प्रेस्क्राइब नहीं है. दैट इज व्हाट वी हैव स्टडीड अ लॉट, कि कहीं पर भी कि मीनिंग देयर बाय कि हो सकता है वो नोटिस 10 पेज का एक बड़ा सा बना करके डिटेल में दे दे और उसके बाद में उसकी समरी बनाए DRC 01 में, विच इज टू बी अपलोडेड ऑन पोर्टल इलेक्ट्रॉनिकली. चलो एक मिनट तो छोड़ देते हैं, लेकिन DRC 01 में भी he has to state the grounds and he has to state the amount. Then 75 very clearly says that the adjudicating authority cannot travel beyond the grounds or the amount specified in the show cause notice. So वहां पर the moment SCN is issued, SCN is again a show cause notice. Show cause notice again opportunity. सुप्रीम कोर्ट ने दो अलग अलग जजमेंट्स में बोला है कि वी आर नॉट हैप्पी विद द अप्रोच ऑफ द हाई कोर्ट टू admit writ against the show cause notice because this show cause notice is nothing but an opportunity. अगर आप अपॉर्चुनिटी लेवल पर ही आप कहोगे अपॉर्चुनिटी भी नहीं चाहिए, कुछ भी नहीं चाहिए, तो फिर हाउ वुड यू एडजुडिकेट? तो वहां पे उन्होंने कहा कि हाई कोर्ट शुड नॉट एडमिट द रिट बट द असेसिंग शुड कोऑपरेट विद द डिपार्टमेंट एंड गिव द रिप्लाई. तो अब यहाँ पर जैसे मेरे पास SCN आया है तो उसके बाद मुझे देखना है, मुझे अपीयर होना है एडजुडिकेटिंग अथॉरिटी पर. यहाँ पर सब चीजें एक तरह से फिक्स्ड हो गई हैं कि एडजुडिकेटिंग अथॉरिटी कैन नॉट ट्रेवल बियॉन्ड दी SCN आइदर इन टर्म्स ऑफ द अमाउंट और इन टर्म्स ऑफ द ग्राउंड. तो मैं कन्फाइन कर गया, उसने अगर 5 ग्राउंड लिए हैं तो मैं उन्हीं 5 पे कन्फाइन करूंगा, उन्हीं 5 पे मैं आंसर दूंगा. देन एट द टाइम ऑफ गिविंग द रिप्लाई आई हैव टू गिव द पैरावाइज रिप्लाई दूंगा और फिर उसके बाद मैं रिप्लाई फाइल कर दूंगा. रिप्लाई इज अगेन फाइल इलेक्ट्रॉनिकली. उसके बाद वो मुझे DRC 06 इशू करेगा जहां पे वो एक्सेप्ट करेगा, रिजेक्ट करेगा. इन बोथ द केसेस ही विल इशू मी द ऑर्डर इन DRC 06 जहां पर वो मेरी बात को मान भी सकता है, नहीं भी मान सकता है, विच इज सर्टेनली अपील. तो अगर SCN मेरे पास 6 पॉइंट का इशू हो गया, 6 ग्राउंड का हो गया, एडजुडिकेशन जो हो गया वो 7 का हो गया, या उनमें से अगर किसी 7th पॉइंट पे हो गया, इन दैट केस इट इज ए 100% चांस दैट द नंबर ऑफ सुप्रीम कोर्ट जजमेंट एज वेल. पर लेकिन हमारे तो लॉ में क्लियरली लिखा हो सेक्शन 75 में दैट ही कैन नॉट ट्रैवल बियॉन्ड इट, तो वो तो केस हमारे फेवर में होगा ही होगा. तो एट द टाइम ऑफ द रिप्लाई द SCN वी मस्ट लुक एट द SCN वेरी केयरफुली एज वर्मा जी हैज ऑलरेडी टोल्ड. उसका पैरावाइज रिप्लाई बनाए, एक एक पॉइंट को कवर करते हुए. जैसे होता है ना एग्जाम में हर एक क्वेश्चन को आंसर करना होता है, 10 क्वेश्चन है, 10 के 10 आंसर करने, ऐसा नहीं 10 में 7 देंगे पासिंग मार्क्स आ जाएंगे, पासिंग नहीं है तो वो 3 रह जाएंगे, वो 3 तंग करेंगे, तो वही हमारे आगे वो काम में आएंगे. तो वी हैव टू रीड दी SCN केयरफुली, देन वी हैव टू रीड दी ऑर्डर केयरफुली, एंड फर्स्ट ऑफ ऑल द फर्स्ट स्टेप वुड बी टू कंपेयर एंड फाइल दी अपील बिफोर दी appropriate authority. अपील में मैं एक लाइन और ऐड करना चाहूंगा बिकॉज टाइम इज नॉट दैट मच. अपील में टू बिगन विद, टू स्टार्ट विद ऑलवेज कैलेंडर ऑफ द इवेंट्स. हाई कोर्ट में जब कभी भी रिट फाइल होती है, अपील फाइल होती है, वी ऑलवेज फाइल द कैलेंडर ऑफ द इवेंट. कैलेंडर ऑफ इवेंट बनाने से अगर आप अपील में भी बनाएंगे तो केस काफी कुछ क्लियर हो जाता है, क्रिस्टलाइज हो जाता है कि इस दिन ये हुआ था, उसके बाद ये हुआ था, उसके बाद ये हुआ था. अल्टीमेटली लास्ट तक आपके 10-12 लाइन में आप आगे देखेंगे एक बार एक कैलेंडर इवेंट बनाया तो उसके बाद आपकी आधी अपील तो उसी टाइम तैयार होनी शुरू हो जाती है, क्योंकि दिस कैलेंडर ऑफ इवेंट मेक योर केस मोर क्लियर टू दी अपीलेट अथॉरिटी एज वेल. उसको भी समझ में आता है. तो वहां पर मेरा सजेशन यही रहेगा कि कैलेंडर ऑफ इवेंट को बड़े अच्छे से बनाए. एक और मैं इसमें रूल टच करना चाहूंगा, रूल 112. वर्मा जी ने स्लाइड के थ्रू बोला है, आई एम टेलिंग थ्रू द रूल 112 that production of additional evidence before the appellate authority or the appellate tribunal will be discretionary and it is not mandatory for them to admit them. There is a difference between the grounds and the evidence. Grounds is certain, जैसे वर्मा जी ने बताया, but evidence is you are submitting certain additional document. For example, High Court का केस है, उसी के उसमें बता रहा हूँ, कि मैंने SEZ को एक्सपोर्ट करा, मैंने वहां पर हमें क्या चाहिए होता है, SEZ का एक इंडोर्समेंट चाहिए होता है बाय द स्पेसिफाइड ऑफिसर। मैंने एडजुडिकेटिंग अथॉरिटी के पास वो इंडोर्समेंट फाइल नहीं करा, मैंने उसके बाद अपीलेट अथॉरिटी वहां पे भी नहीं फाइल करा, हाई कोर्ट के पास में पहुंच गया, हाई कोर्ट का जी देखो जी अपील तो मैं ट्रिब्यूनल तो है ही नहीं, अब इसको आप एडमिट करो। हाई कोर्ट ने कहा कि रूल, हाई कोर्ट ने स्पेसिफिकली रूल 112 को कोट करा कि दिस हैज टू बी गिवन ओनली एट द एडजुडिकेटिंग अथॉरिटी। जो डॉक्यूमेंट आपने फर्स्ट लेवल पे, वी आर नॉट द फैक्ट फाइंडिंग अथॉरिटी, हम यहाँ पे दोगे ना हमारा फॉर्म देखने बैठ जाएंगे कि आपने क्या डॉक्यूमेंट दे रहे हो क्या नहीं दे रहे हो। उन्होंने रिट वाज रिजेक्टेड merely by reading rule 112. So please be careful that whatever the documents are to be given, that should be given at the adjudicating authority level itself, and at the most अगर लिबर्टी लेकर के आप लेकर के अपीलेट अथॉरिटी के लेवल पे फाइल करें। एक लास्ट लाइन कि अगर कभी भी एक्स पार्टी ऑर्डर होता है तो एक्स पार्टी ऑर्डर में अगर मान लीजिए एडजुडिकेटिंग अथॉरिटी कुछ कर देती है तो वी हैव गॉट नंबर ऑफ केस लॉज दैट एक्स पार्टी असेसमेंट कैन नेवर बी द वाइल्ड असेसमेंट। हमारे यहाँ दिल्ली हाई कोर्ट की दीपक इंडस्ट्रीज की भी जजमेंट है, दैट हैज टू बी बेस्ड अपॉन द मटेरियल्स अवेलेबल ऑन रिकॉर्ड कि अगर मैंने एक अपील पूरी की पूरी फाइल करी है, अभी मनमोहन जी ने कहा था कि हम बाद में फाइल करें या पहले फाइल करें, तो अगर हमने पहले लेवल पे फाइल कर दिया है और पहले लेवल पे हमने जो कुछ भी फाइल करा है और मैं उस दिन किसी वजह से नहीं जा पाता हूँ और वो एक्स पार्टी कर देता है, तो एक्स पार्टी जब वो करेगा तो ही इज ड्यूटी माइंड टू कंसिडर ऑल दी पेपर्स अवेलेबल बिफोर हिम। तो जितने भी मैक्सिमम सबमिशन, जो डिटेल सबमिशन है तो बात की बात है, लेकिन जितने मैक्सिमम इस तरह के जो एविडेंसेस हैं, डॉक्यूमेंट्स हैं, अगर पहले हम फाइल कर लेंगे दैट वुड बी बेटर। एंड लास्टली ग्राउंड्स ऑफ अपील, वर्मा जी ने बड़ा वो किया, टेक ऑल द ग्राउंड्स वट एवर नेसेसरी एंड व्हाट वी हैव बीन टोल्ड दैट टेक द बेस्ट फुट फर्स्ट, सो दैट कि आपका जो मेन ग्राउंड है सबसे पहले धीरे धीरे उसको आप उसका डाउन करें। तो दिस इज विद what I can conclude, because I cannot conclude this session because where there is no scope of adding something. This is what I have just for the sake of addition I have added, because otherwise I don't have anything much to say. Thank you friends, thank you very much.
Thank you very much, Garg Sahab, for concluding in a very precise and concise manner. And definitely there cannot be conclusion of such a big topic in subject in one session. We will definitely have more and more session, and time is running very fast. So I straightforward request our member Ravindra Kumar Jain ji to put a formal vote of thanks for the galaxy of the speakers, panelists and the participants today. Ravinder ji.
Thanks Manmohan ji. मेरी आवाज आ रही है
रविंद्र जी।
Thanks Manmohan ji. So I on behalf of CAVM chairman and on behalf of Raj के Batra study circles, thanks to our learned speakers CA सुशील वर्मा जी, जिन्होंने अपना बहुत valuable time निकाला और बहुत हमें अच्छा मतलब educate किया, and I thanks all the panelist members जो उन्होंने भी time निकाल के और हमें बहुत support किया, and all the members also who has joined in a huge numbers, and जो अभी तक patiently hearing कर रहे हैं, सुन रहे हैं उस बात को, तो next time हम उसका थोड़ा सा और time जल्दी ही आप सबको update करेंगे, and now so again I thanks to Advocate Sushil Verma ji and a big allow.
Thank you very much all. Thanks for joining. Please put your please Sushil ji wants to give a final remarks. Please Sushil ji.
No friends, I am not discussing subject. I am only discussing जिन यंग लोगों ने जितने बड़े कमेंट लिखे हैं हमारे बारे में या राकेश के बारे में या किसी के बारे में, thank you so much for all that. I think these are the maximum number of chats I have seen in any of the webinar programs. Out of 120 people, around 64 people have given comments. That's remarkable. A lot of questions have been asked and Manmohan has been very kind to answer them. Now, the only request I want to make is with all youngsters, chartered accountants, company secretaries, cost accountants, advocates, please don't feel shy of litigation. That is your future. Get away from this return business. That's killing your life. Life is first. Everything else is later. Get away from compliance work. Do a creative job. It's not a rocket science which you can't learn. If we can learn, you can always learn. If we can, you can. Therefore, buddies, give a new twist to your career and come into litigation. May God bless you all. We do it again very soon. Thank you, Manmohan ji. Thank you, Ravinder ji. Thank you, my friend Rakesh. Thank you, Rajesh Jan. Thank you, Tulya Jan, Ashok Verma, everybody for making this such a big success. Thank you so much.
Thank you very much all. Thank you very much. See you soon in our next webinar and in physical seminars and series of workshops also. Thank you very much.
Thank you.